Huh? Uh.
Good morning, everyone. Good morning, everyone. Welcome to the second day of the ULS Tax Law Symposium 2025. I see we have majority of the participants today choosing to appear virtually. We have about 56. So we believe that's a good number for us to start the day's discussion. I'll request my colleague Vanessa Mbekeka to give us an opening word of prayer, and then we shall roll into the day's discussions.
Thank you, Edwin. We'll humble ourselves for a word of prayer. Heavenly Father, we thank you for this day. We thank you for the gift of life. We thank you for everyone that has made the time to attend this session. We pray that we will be enlightened, we will learn, we will grow. You'll bless the speakers, you'll bless the moderator, and everyone that has chosen to attend. All this we have prayed, believing and trusting in your holy name. Amen.
Thank you so much, Vanessa. Before we proceed, I would like to recognize the presence of senior advocates that are here with us, and also some appearing online. I've seen Mr. Oscar Kambona from KAA. I've seen Mr. Ronald Kalema from AF Panga. I've also seen Mr. Edward Balaba from Max Advocates. Online, I've seen Mr. Dennis Kakembo from Crystal Advocates, and also Mr. Godfrey Akena. Everyone, those appearing online and those here with us physically, you are most welcome to the second day of the ULS Tax Law Symposium 2025. Maybe for the benefit of those that were not with us yesterday, we had very fruitful discussions covering a wide range of topics. We started the day with a panel discussion on the dispute resolution landscape. As far as taxation is concerned, we were able to appreciate with numbers and figures the impact that alternative dispute resolution has had since its introduction a few years ago. We were also able to hear from the chairperson of the Tax Appeals Tribunal what the tribunal views as some of the concerns that are probably hindering effective resolution of disputes. And one of the issues that came out very clearly is the issue of timelines. I think the numbers spoke to about 30% to 20% of the disputes lying in the Tax Appeals Tribunal, centering around failure by taxpayers to observe timelines. When an objection decision is served onto the taxpayer, there are 30 days within which to file an application for review to the Tax Appeals Tribunal. And in the context of ADR, the taxpayer has 7 days from the date of the decision to apply for alternative dispute resolution. The panel emphasized the need to respect timelines so that taxpayers are not locked out of the dispute resolution process and have them condemned to liabilities without being heard on the merits. Then in terms of appeals from the Tax Appeals Tribunal to the High Court, and also from the High Court to the Court of Appeal, Mr. Kefas Birungi from Birungi Barata emphasized again the need to observe timelines, and also bearing in mind that those particular appeals only lie against questions of law. And he also emphasized the need for the notice of appeal in the respective instances to set forth concisely the areas of contest so that you ease the work for the court to understand the dispute and be able to provide justice to the respective parties. Then we also had another discussion regarding recent trends in capital gains taxation in Uganda, which focused largely on the application of Section 78H and Section 74.2 regarding direct and indirect change in ownership of companies in light of the decision in EnviroServe versus Uganda Revenue Authority. I think what came out clearly is the need for reform, particularly in light of the possible interpretations that perhaps make those particular provisions applicable to local companies, even in cases of direct changes in ownership. I think what the panel stressed is that that particular position may not be in the best interests of a growing economy like ours. And so the discussion in that regard will continue. We also looked at land disposals and capital gains tax, tax in quotation marks, that's essentially income tax, arising from disposal of land. Of recent, we have seen a surge in assessments coming in from the Uganda Revenue Authority targeting capital gains from disposal of land. So the panel was able to take us through what amounts to a business asset, considering that the capital gains taxation framework focuses mainly on gains from disposal of business assets. So we were able to look at what amounts to a business asset, what considerations need to be taken into account in determining whether a particular asset has become a business asset. Then lastly, we looked at withholding tax on the sale or disposal of mortgage property, essentially foreclosure sales, in light of the now two seemingly conflicting High Court decisions in Lualua Investments versus Uganda Revenue Authority by Justice Thomas Rochaya, and a decision that came out last week by Justice Mubiru. Two High Court decisions seemingly pulling in opposite directions, one saying there is no withholding tax on foreclosures, and another seemingly suggesting that withholding tax should be applied. So we had, again, a very fruitful discussion on that particular aspect. That's just a recap of what we had yesterday. I believe the discussion will continue going forward, but for now, and to start us off for today, I will hand over to my colleague Vanessa Mbekeka to start us off. Thank you, and you're most welcome.
Thank you, Bruno. Good morning, everyone. My name is Mbekeka Vanessa Irene. I am a senior associate at AF Mpanga in the tax department, and I'll be the moderator for the first session. So our first session today focuses on a vital and very dynamic area, which is mergers and acquisition tax issues in Uganda. Navigating the tax landscape in relation to M&A tax issues has increasingly become quite complex, and it requires deep expertise to balance deal structuring, compliance, and basically to have the best strategic business outcome. And we are honored today to have Mr. Edward Balaba, a seasoned corporate and tax lawyer with over 14 years of tax experience, to lead this discussion. Edward is currently a tax partner at Max Advocates, where he provides practical tax advisory services to a wide array of clients. He holds an LLM in International Tax Law from King's College, London, as a Chevening Scholar. He also has an advanced diploma in International Taxation from the Chartered Institute of Taxation in the UK. He also has a postgraduate diploma in legal practice from the Law Development Center and an LLB from Makerere University. He is also a proud member of the International Fiscal Association, the Uganda Law Society, and the East African Law Society. Please join me in welcoming Edward Balaba as he shares very valuable insights and practical guidance on M&A tax issues. Over to you, Edward.
Thank you. Thank you, Vanessa. Thank you, Uganda Law Society, for the invitation. So the discussion we are having today around mergers and acquisitions is very topical in light of businesses, because businesses tend to change form, structure, organize and reorganize differently across their life cycle. So we'll effectively look at some foundational issues. I mean, I call them foundational because they're important, but we will not discuss them. We will focus on the tax and not necessarily the corporate, side of how either the deals are structured or what kind of deals exist. We'll illustrate how a merger or an acquisition structure looks like, and just to have you understand, just a simple structure for you to register and understand how it tends to look like. And then effectively, the bulk of our discussion will be around the tax issues that arise. Will there be withholding tax in some parts? Will there be capital gains tax? Will there be stamp duty? And then value-added tax? Or will any of those be exempted? Or will you have to be relieved from any of those taxes? So that will form our discussion today. So to start off, a bit of foundational issues. A bit of foundational issues in terms of how it works. So you will have to choose, and these are very very vital decisions to make, but you'll have to choose how to structure that particular transaction. There is a huge debate around if you're going to be an investor, if you're going to acquire an interest or business, is it safer to actually purchase shares, or do you actually purchase its assets and by extension its liabilities? Or is it either of both? So that's a very big discussion. It turns many times on the tax, because there can be tax advantages of one over the other, but it also has to apply to specific circumstances. You cannot say, for example, that a share purchase is always more tax advantageous. I mean, you might find a scenario where purchasing assets as opposed to purchasing shares in a company would actually be a better option. So it's down to a case-by-case scenario, but that usually is at the back of most of these transactions. How do you get in? How do you acquire this business? Do you just become a shareholder, or do you just buy the business itself? Very important. Now, as part of these processes, again, it's important to know what one is buying. So there is usually an elaborate due diligence process. So it's either the buyer or the seller who is interested in knowing. I mean, you don't want to buy an entity either by way of shares or its assets, and you actually don't know the risks, that you're having to take on, or you don't even know whether or not there are any issues that relate to that business. So you will find a financial due diligence, a legal due diligence, a tax due diligence being almost something that you must do, because then you need to ascertain what you're buying or what you're acquiring in this case. Financing considerations, depending again on the structure. I mean, is it an acquisition? Is someone having to, is it a merger in exchange for shares? Is it in exchange for cash? Is it in I mean, it can get more complicated. Is someone giving loan notes, or so many other creative ways to go about it? Now, the key thing here is one then has to be careful, because either of those could have different tax implications depending on how you have chosen to finance that transaction. So again, it's not something we'll delve into, but these are foundational issues that one ought to know. If the merger has cross-border issues, then you have a different set of tax issues to also worry about. I mean, is it that some of the entities involved are actually not Ugandan entities? Then you might have a different set of tax issues to worry about. Is it part of an existing group? In which case, it's a group, so it exists. Or is it someone getting into a group? Or will the group only arise after the merger has happened, or after the acquisition has happened? So all those are important because they may have specific tax implications. For example, if it's a group and it turns out to be a mere reorganization without a substantial change in underlying ownership in that group, then you might escape some taxes. So all these are important things to think about, and these are just some of those. The key thing is that this presentation will not delve into, corporate restructuring issues. I mean, how are you doing it? Is it in what exchange for what? Are you canceling shares? Are you exchanging shares? Is it money? What's happening to the disappearing company or the surviving company? We will focus on the tax and in broad terms. But in terms of types, again, you will find these two being thrown around, M and A, but you might actually find that maybe the structure is just a merger, or it's just an acquisition, or it has both steps at some point. You have an acquisition at some point, you have a merger at another point. And there are also similar things. Corporate divisions, because merger is bringing together, corporate division is essentially splitting. And again, the language varies. Different things exist. I mean, if the people involved are from the USA, for example, you'll hear words like spin-offs, split-offs, to try and explain what they are trying to do. If it's a UK, you will find things like partition and the merger being used. In our law, that's essentially what we either call an amalgamation for a merger or a corporate division for a demerger. So that is how it works. But like I said, this will not be the focus of our discussion. It's just for context. It's just for you to understand that the tax then will have to be based on these kinds of scenarios. So you, in essence, then you can't assume that the tax implications on one transaction should exactly be the same on another transaction, because it depends on how it has been structured. Okay, so that said, a merger would, so this is a very simplistic illustration of how it happens, or how it can happen. So assume you have all those companies. So you essentially have a group. So you have a company A, company B, and those two companies hold shares in a company C, and then C also holds shares in companies D and E. So the question usually is, and these are sometimes business reasons, really. You want, some efficiency around your business, or you might have just found a new investor who wants to take over, and they would want to do it differently. So on the left-hand side, you will find what you have as a pre-existing transaction. That's the before. Now let's assume that both A and B choose to transfer their shares in C to a new player, F. So F is a new entrant, possibly has been outside the group, but some kind of investor that has come on board. So in that case, it means that at that level, A and B no longer hold C. So the one that holds C is now F. So you see that's now a change. So that has happened. And then at the next level, after acquiring that, F finds it important to reorganize his business and merge both D and E. So where you had two separate entities of D and E, you now have them merged, which is your typical merger or amalgamation. So it's either you're creating a whole new entity, or you have one of the entities surviving and another one disappearing. But essentially, you end up with only one entity surviving. So that's the kind of scenario. And then let's assume A no longer has any business to do. All it had to do initially was that it was a company whose only role was to invest shares in C. So if it has disposed of those shares, then you can as well liquidate it. So you have A liquidated. B, let's assume B had assets, and those assets have since been transferred to, say, C. So in effect, it's also a shell company, no longer holds any shares, and possibly you can make a choice to liquidate it. So you see how that changes. So you possibly had a group existing, just the way it looks on the left-hand side, and then after that merger, so what do you have in this case? You have a merger happening at some point, you have an acquisition, and you also have a liquidation that has happened, all in the same transaction. So this is quite common. This is your typical kind of transaction and how it plays out. So from just looking at this and what has happened, you then start wondering what of the different things that have happened at different levels, what then are the kind of tax triggers? I mean, in terms of what taxes should you be worried about, and who should even be worried about these taxes? Is it the one who transferred the business? Is it the one who acquired the business? So we go through a number of triggers. So to the extent that there has been a disposal of business assets, then you have capital gains tax to worry about, especially if that disposal of business assets is at a gain. So that's a trigger. Have we seen any disposals in our earlier structure? Yes. So you've had shares moving, you've had assets moving. So to the extent that those are actually business assets, then you're potentially inviting capital gains tax. So you have to think about it. And then there is room for a relief called a rollover relief, but that we shall discuss. So business assets. There was a long, drawn-out discussion yesterday about this, so we'll not repeat it. But this can be the shares. That can be the business asset that you've disposed. It can be any other assets being held by the company as business assets. So the first tax triggered there is a potential capital gains tax. The second tax issues triggered relate to, again, that same disposal and acquisition arrangement could give rise to some corporation tax issues. Now I'm calling this corporation tax because it is arising because some of the assets that you've had to dispose or acquire are not necessarily amenable to capital gains tax. And typically here you're talking about depreciable assets. So there are also corporation tax issues to worry about. Okay? What will you have as the cost base? I mean, you have acquired, yes, but at what cost base? What cost base are you going to report in your books? And that becomes important because you want to use that cost base going forward to enjoy some capital allowances. So you have something called a depreciation allowance. If it's industrial buildings, you have something called an industrial building deduction. So again, that's another trigger to think about. Has there been any purchase of business assets? If you look at that structure again, yes. So if that has happened, then you might have to be careful about withholding tax. So we'll discuss which withholding tax issues will arise typically in an M&A situation. Has there been transfer of assets? Yes. So stamp duty tends to arise at this point. We all know that transfers attract a stamp duty of 1.5%. So again, it depends on the business. If the business that you've had, or if the companies involved or the assets involved gave rise to instruments that are technically qualify as transfers, then you will have to worry about that. Typically, this is assets, this is shares, and then land, titled land, where you'll have to have a 1.5% stamp duty. In a group situation, the transactions will typically have happened between associated persons. Again, this associated persons concept was discussed yesterday, but essentially these are related persons. So if that has happened, then you have to be keen about at what price, because that might be challenged if it is not at the proper arm's length for transfer pricing purposes. So what works legally may not work tax-wise. You know, for example, you might transfer your business for $1 and legally there is no problem. I mean, all you're saying is there is consideration. But if you are associated persons, then there are issues because the taxman will not accept. The law on transfer pricing will insist that the price should be that price that independent parties in the market would have used or should use in terms of what are comparable transactions. Lastly, we will discuss VAT, because again, in this kind of arrangement, you've seen that there has been a supply, there has been a transfer of goods and all. So you might have VAT to actually worry about. So those 4 or 5 are the key tax triggers that we will have to focus on in most of the deals or transactions. So we'll start with withholding tax. Again, this has been discussed, was discussed yesterday, but it arises in these situations as well. Because from our example, you see that some assets have actually been purchased or sold for that matter. Now, to the extent that the assets have been purchased by a resident person, so a resident person, and it's an asset. I mean, I haven't said business asset, I have said asset. So that is broader. So to the extent that just an asset has been purchased by a resident person, and the one who has actually sold that asset is a non-resident, there is a potential 10% withholding tax to think about. Now, where the purchase is by a resident and the specific asset is either a business asset or a business itself, then you have 6% withholding tax to worry about. So this is withholding tax. Again, the same structure, the same transaction, but you must be careful about these taxes. There was a discussion yesterday around this 6% withholding tax on properties like land. So If part of the transaction has assets like land, then you have to be careful. But at the end of the day, what ought not to be lost is that this withholding tax is not a final tax. In fact, it's only a collection mechanism of a corporation tax in this case. So you can safely call it an advance payment of a capital gains tax. Now, if that is the case, then it would mean that if at the end of the day there is no capital gains tax, then there shouldn't be withholding tax as well. And this is what the tribunal has just confirmed in a recent decision of Tunga Nutrition. I mean, to the extent that, yes, you have purchased an asset, okay? So in that case, as a purchase of the asset, you have had to pay. You have an obligation to pay less withholding tax as a buyer. But if in the grand scheme of things, that is not a transaction that should have capital gains tax, in this case, the one before the tribunal, the transaction qualified for a rollover relief, then it wouldn't make sense to ask for an advance capital gains tax when there should not have been capital gains tax. So that's something to think about. But if that is not the scenario, then the withholding taxes will have to apply. Let's move to capital gains tax as another tax to think about. So again, in our structure, were we able to see any disposals? Yes. So someone has either had to dispose shares, or if the asset makeup has things that are non-depreciable, like land, then you have got to be careful, because as the person disposing of those assets, in this case business assets, if that happens at a gain, that means if a comparison is done between what it is that you have received with what it is that you use to acquire that asset, and there is a positive difference, which is a gain, then that gain will be subject to capital gains tax, which is not a separate tax. So the rates that apply to income tax will actually apply to it. So you have to be careful. And in terms of the transaction, you might not have even called it a sale, you know. It might be a group, and all you have had to do is to transfer some assets or to exchange them, but all that is captured as a disposal. So to the extent that it's a disposal, capital gains tax, if there was a gain, will actually apply. So one has to be careful about that. If the disposal is between associates, again, I can't overemphasize, you can't use any price. You must have a semblance of a fair market value based on transfer pricing considerations. So that has got to be done. Now, the other common thing in these transactions, a very common practical issue, is where, because as far as you're concerned, you are either disposing the entire business or a whole set of assets, and some people don't find it important to split and assign different values to the different assets. The challenge with tax is that at the end of the day, you might find that different assets that are part of that bundle will have different tax implications. Now, one then will have to go through the exercise of determining how much of that consideration, which was paid without being split into the separate assets, relates to the specific assets. Now, the law guides and says in case of joint disposals like those, you must assign a fair market value to the respective assets. So again, as part of planning, it might be helpful that even while you're selling the land, the buildings, the plant and machinery, it might be tidier for tax purposes to actually have different prices allocated to the different issues. because at the end of the day, you might have different tax implications. There are assets that tend to be very unique. So if part of what you're transferring has intangibles like customer lists and all, you might have unique tax issues to deal with. If for example, you're a non-resident, then those intangibles will qualify as part of your immovable property, and immovable property will be taxed a specific way. You might have other assets like land, which also have their own issues. You might have buildings, which qualify as industrial buildings, which will also have their own tax issues, which in the interest of time, we might not be able to go through each and every one of those. But it's important to think through all these issues. So that was an actual disposal. So you've actually disposed the business. The second risk in these transactions is where the transaction involves a deemed disposal. So the disposal has not directly happened in the Ugandan company, but has happened elsewhere. Again, there was a lot of discussion about this yesterday, so I'll not spend a lot of time on it. But you might get into the weeds of this if that happened. If part of your structure is such that the group had to first do some disposals of shares, somewhere offshore before, they later reorganize the Ugandan company, or even if they have not reorganized the Ugandan company, but that has happened, then you run into a capital gains tax, which is based on a deemed disposal. Now, it's not a deemed disposal of shares because you've not disposed shares in Uganda, but it's a deemed disposal of the assets of the Ugandan company. So what's the logic? The logic here is that, yes, we agree technically, legally, you didn't change shareholding in the Ugandan company, but by changing shareholding in maybe its holding company or its other intermediate company somewhere offshore, then there is an assumption that you dispose the actual assets in that company, in the Ugandan company. So if that is the assumption, then the Ugandan company's assets and liabilities, again, the discussion was had yesterday as to whether it's assets and liabilities or just assets. But if that is the case, then you are assumed to have sold them. I mean, you haven't sold them, but the law assumes you have sold them at market value. So there's an exercise to try and compare your market value in terms of those assets as at that date with the cost base of those assets, which if the assets are subject to capital allowances is something we call tax written down values. So if you compare the two and there is a gain, then you pay tax. Okay? If you compare the two and there is no gain, then there is no tax to pay. So it's either you have a gain, in which case you have tax to pay. If you have a loss, you have a deductible allowance for that loss. Or if it's a no gain, no loss result, then there is no tax effect in that case. And then going forward, because the law has assumed that you have disposed of your assets, going forward, those assets will now take the value of the market value. So we call it a rebasing of assets. So that might be higher, it might be lower, but depending on what value you got from the professional, in this case, a valuer. Okay? And that works just like that, but there was a detailed discussion around this yesterday, which we don't have to repeat. Now, there is room for not paying the capital gains tax in these kinds of transactions. But that is if you meet the criteria, the conditions that have been set for a relief that is called the rollover relief. Okay. Now you don't pay that tax, but it's not an exemption, because what happens is that the tax is postponed to another time when those assets are transferred. And what is the logic? The logic is that if in economic terms, in economic reality, you actually have not had a change in ownership of that asset. I mean, it's either a case of, I used to hold this asset as an individual, now I'm holding it as a company. Okay? But you're exactly the same person. You're still the majority shareholder. So you might have this relief afforded to you. So one of those things is if you transfer an asset and you're a resident person in exchange for majority shareholding. So a new company is set up, you've transferred those assets to that company, but even in that new company where the assets have been transferred to, you are the majority shareholder. So that could be one to think about. The other one, I hope you remember the liquidation we had. The other one is if assets are being distributed at liquidation, but still they are going back to the majority shareholder. Again, there is room, subject to additional conditions, to qualify for rollover relief. The one that is commonest for mergers like this is called a reorganization. So if you have a resident company or you have a group of companies and you have reorganized them without changing the underlying ownership, again, that's the key condition, that the people that were holding that company are essentially the same people who are holding that company, either directly or indirectly. But in effect, you can say that in economic circumstances or by way of economic reality, the owners remain the same, even when they have changed legally. You might enjoy that reorganization. So how does it work? One, which was again discussed yesterday, an amendment for this year, is that if you transfer assets to a majority shareholder, now who is transferring assets? Any person. So any person transferring to a resident company where you already the majority shareholder. So you might have room for a rollover relief. In our case, if it's a merger, so you have had a merger where a company has transferred all its assets, or several companies have transferred all their assets to a single company, and then those companies that have transferred the assets cease to exist, the merger is defined as part of a reorganization, and in which case then you will not have to worry about capital gains tax. There are a lot of nuances, there are a lot of details which we don't have time to go through, but it is something that you need to examine closely. Now, a mere sale of shares is not a reorganization. So if all that has happened is that one person has sold shares to another, that is not a reorganization. So it's important that that is taken care of. Again, the relief is called a rollover relief. So in effect, at that stage, you will not be taxed, but at a subsequent stage, the cost base of those assets that have been transferred will be preserved for future capital gains tax purposes. So that's how it works, and that's how you navigate the capital gains tax issues around M&A. So that's capital gains typically. Now, just a quick note on corporation tax. So for corporation tax, here you're talking about assets that are involved that are not necessarily amenable to capital gains tax. So you're talking about assets that are instead dealt with by corporation tax. Most of these, we call them depreciable assets, because for corporation tax purposes, they enjoy wear and tear, a depreciation allowance. They are grouped into 3 separate classes, and every other year, a taxpayer is entitled to a depreciation allowance for them. Now, if part of what you have had to transfer or acquire involves any of these assets, then the tax implications are not necessarily capital gains tax, but they are similar. So, for example, if the general effect of you transferring one asset within that class of assets, because again, it's about what happens to the entire class or pool of assets. You might end up with what we call a balancing charge, which is taxable. That's as good as a capital gain, but on the side of corporation tax, or you might end up with a balancing allowance, which is deductible. That's if it's at a loss. That's if the whole pool now has gone into a loss. So it's important that this is well thought through, because in a transaction, this could be, very important as to whether the transaction is structured one way or the other. So again, for depreciation allowances, the person who is acquiring the assets in terms of the acquisition has to be careful about what am I going to get for capital allowances. So if there are depreciation assets, then the acquisition price is what you will book or recognize as your tax written down value to be used. However, if it is industrial buildings, there is a catch here. So if the building is actually a building you got at 1 billion, but the previous owner of that building had enjoyed industrial building deduction up to 200 million. So even if you bought that building at $1 million or 1 billion, you will not enjoy industrial building deduction on the basis of how much money you paid. You'll have to just pick up from where the previous owner of the asset stopped. For example, if they extinguished, because industrial building deduction is 5%, so 5% across 20 years, you have extinguished the whole value. So if you buy an asset that no longer has any industrial building deduction, whether you have bought it at 1 billion or 6 billion, it doesn't matter. You will have no industrial building deduction left for you to enjoy. So this is important. And then finally on corporation tax is another restriction. When there is a change in control, which is what we have seen, you've had to change shareholding to someone else, there are restrictions. And these restrictions are in tax losses of the company that has changed control. So it's possible that someone can buy into a company because that company has huge tax losses in order to enjoy those tax losses. And then it's also possible that when they get in there, all they do is change the business of that company and then are able to enjoy those tax losses. So there are restrictions. There are restrictions that if you have had a 50% or more change, then you will only enjoy the tax losses in that new company that you have acquired if for 2 years or for the duration of the time when you exhaust the losses, you continue with the same business. Okay? And you don't start a new business with the principal purpose of trying to enjoy those tax losses. This has come up for litigation. The Warid Airtel merger acquisition has been before the High Court and over this issue. Everything else was resolved. Everything else had reliefs except this, where the tax losses of the huge tax losses that Warid had, the question was whether or not Airtel should actually enjoy those tax losses. It's a bit of a problematic decision because it uses provisions on change on control restrictions, but it's actually addressing an issue of transfer of tax losses. But anyway, it's a case that is interesting to read and find out how these things work out. Stamp duty, did we have any transfers in the transaction? Yes. So if you have transfers, you have a 1.5% stamp duty. So this could be shares, this could be titled land, anything that has an instrument called a transfer will potentially have 1.5% stamp duty. Effective July 2025, you don't have stamp duty on agreements anymore. So again, one of the common things is the agreements you've had to use either for a share purchase or an asset purchase would always have stamp duty. Now they will have stamp duty, but nil stamp duty, which is effectively no stamp duty. Okay? So it's important. The stamp duty on transfers, it's assessed based on valuation. So whether it's shares, those that have transferred shares at URSB know that you must have a valuation form. Those that transfer land with the Ministry of Lands know that the chief government value has to determine the land, because that's what the law on stamp duty provides for. Are there some exceptions? Can you escape this stamp duty? Yes. So two specific exemptions arise in these scenarios. So there is one that is specific for amalgamations. These are mergers. And there are conditions for it. But if you've had to set up a new company, if you've had to increase share capital, if you've had to transfer shares, but all that is because of an amalgamation or a merger, okay, in which the company that is acquiring those shares is actually acquiring at least 90%, then you will not pay stamp duty. So you will not pay stamp duty on increase of share capital. You will not pay stamp duty on the companies being registered for that purpose. You will not pay stamp duty on transfers of shares. So that exists. It's a very problematic provision, but it exists, subject to approval of the Commissioner General, Uganda Revenue Authority. The other stamp duty exemption in these circumstances is a transfer between associated companies. So associated companies in this case are those that either directly or indirectly are held, they have common ownership. And that common ownership for stamp duty is defined at 90%. So if you don't meet 90%, you don't bother, because you will not get these exemptions. Lastly is VAT. VAT only when you're transferring assets, because transferring shares has no VAT. But if what you have chosen to do, if the structure of your deal is to actually transfer assets, then those assets will be subject to 18% VAT. That's transfer, especially if the person transferring, there are qualifications, thresholds and all. But unless the asset is itself not subject to VAT, but if the asset has not been exempted from VAT, then the transfers will be subject to VAT. But again, there is room for an exemption. And that is when you meet something, you meet the conditions for what is called a transfer of a business as a going concern. So how does that work? It means that what you have transferred is not an isolated asset, but a bundle of assets that are capable of separate function or operation. So you basically had a business or a line of business, and you've transferred that line, and it's capable of a separate operation. So if that happens, and both the buyer and the seller are VAT registered, then there is room for a VAT exemption where you don't have to worry about the 18%. There are some detailed requirements that you could look up. So there's a URA practice note of 2008 that lists about 8 or 9 things, including a case by Apollo Hotel, the concession, and whether or not that was a going concern that should qualify for the exemption. However, if all you have transferred is an asset, again, remember we are talking about a business, so it has to be some kind of business that is capable of a separate operation. To the extent that it's just an asset, then that is not a supply of a going concern, and you will therefore not be able to get any exemption for VAT purposes. The VAT will have to apply. So generally that's it. Those are the different taxes to worry about in this space. It's a transaction, so all the transactional taxes are potentially applicable. So you can have capital gains tax, you can have value added tax, you can have stamp duty, And you can also have corporation tax issues if you are a company, because in this space you're largely dealing with companies. So thank you. That's it. Thank you.
Thank you, Edward. That was a very practical presentation. And for the lawyers out there are so many things he has discussed, from foundational issues to consider while you're drafting those share purchase agreements, while you're drafting asset transfer agreements, amalgamation proposals, land sale agreements. A lot of these tax issues have to be taken under consideration. Without further ado, we'll open the floor to any questions for our presenter, Mr. Edward, if any. Those online, you can send them in the chat. And for those physically present, you can just raise your hand and the mic will be sent to you. I understand it's quite a complex topic. So when there are no questions, either you've understood or you've understood. All right. If there are no questions, please help Tony with the mic.
Good morning. Edward, thank you for the presentation. I wanted to pick your mind on something. What is your view on M&Es being used for tax avoidance purposes in respect to these structures of transactions? The first one would be retaining the payments or splitting them into different periods. For instance, on paper, the transaction, the intention of the parties is there, but they say that the payments will happen after a specific time without any reason. Or they say the payment will happen after the purchaser has verified that the transaction they have entered into is a going concern as represented by the vendor. Because we have cases on this side that you look at and you wonder whether a reasonable person would accept to give up their business and get the payments later on. Then the second one would be the hybrid transactions, that you find someone, as an example, is getting equity in the company. But you would expect that when you get equity or shares, you'd probably, what you would get in return would be what you bought, what you got. But what the transaction looks at, the way it is structured and made complex, you find it appears as if they have given a loan. It appears as if they are getting interest in return. Then you find someone as it is debt, but they are getting participation. And because of M&Es, the way they are structured, they are made so complex that sometimes it makes one wonder, what is the issue? What are they trying to avoid? So basically, that was the first question, how they can be used for tax avoidance. Then secondly, in your view, what are the reasons why M&Es are on a rise, on an increase? I mean, on one hand, we have advantages of, if you come here and you start from scratch, with the amount of money people exchange, you can get tax holidays from scratch. You can get other amenities. Why do people choose to mutate? So thank you. If you can address those questions.
Thank you, Tony. I think Mr. Edward can first address those, then we get the next question.
Thank you, Tony, for the questions. You raise valid concerns. I guess like across the world, you have this happening. In terms of concerns. But what we cannot forget is that M&A are actually a natural part of business. Because whereas there is the possibility or the danger of someone using it typically for tax avoidance, it's also true that they, in many cases, are actually genuine business transactions. It's a way to get into a market. So why would you get into a market and start from scratch when you can acquire an already existing business? Why would you be inefficient? Yes, you've been running this group of yours with 10 companies, and you notice they're inefficient. You're paying staff, for companies, but you can actually have them in one. And this can mean you either bring them together or even split them. They could be one thing and now you want to split them, or there are several things and you want to. So it's something that will always happen. For as long as business exists, for as long as investment exists, you've got to have people struggling, so they will have to exit the stage and people will have to take them over, which word, some people don't want to use lately. But, people will be taken over, people will be acquired, people will have to merge because they are struggling. It's about the realities. It's about the economics. It's about the business. So the starting point is that they are actually genuine. On the larger part, they are genuinely informed. They will happen and continue to happen. Of course, why there are possibly more, maybe it could be something about the economy. Is it that there is a lot of issues structurally in the economy, and then people are either having to fail and sell, or are being acquired, or are merging. People are merging to cut costs. People are merging to be more efficient. Yeah. But that said, it's also true from the discussion we had, it's also true that you can tell how many taxes. You've seen how many taxes potentially can happen on that transaction. That tax alone can actually be a deal breaker if that transaction is not well planned. So let's assume, for assumption's sake, that that transaction has a 30% CGT on a gain. It has an 18% on VAT. Someone is taking 10% or 6% of withholding tax at some point. Another person wants 1.5%. Meanwhile, even the assets you acquire for corporation taxes, there is possibly no guarantee that you're going to enjoy the full capital allowances of those deductions. So there is no one who is doing a serious M&E transaction who will not think about the tax. So that is one. So you'll have to think about it. So the planning of the tax around it is not necessarily tax avoidance, but it's having to take advantage of what exists. Now, incidentally, what exists is not even something that you're creating. The law creates it. In all those potential taxes we've spoken to, there is a potential exemption. So VAT, if your transaction is organized in such a way that it's a TOGC, there is no VAT. If it's a rollover relief, for CGT, there is no CGT to worry about. So you even have the law or the tax recognizing that indeed, to some extent, these transactions should not be taxed. And that's why you have all those reliefs. So that actually happens. And I think the mindset is very important, or the attitude. For someone to know that, yes, there are those that are genuine. Of course, there might be those that, border on aggressive tax planning. I mean, Tona has spoken to payments, structuring payments, but that might be part of business. If I'm going to defer payments, it's because I want to be aware of the risks. Because if these taxes arise, it's a deal breaker. I mean, those are taxes that are potentially north of 50, 60% of the value. So why would I go into a transaction when 56% of the value of that transaction is going to pay taxes? I mean, who gains at the end of the day? So you want to be sure. So that is why you'll find things like those. In your typical documentation for M&A, you'll find a lot of warranties. You'll find a lot of people committing to all kinds of things that commit, or money being committed. And part of the biggest risks are tax risks, because you want to be sure that it makes sense. I'll take the case of a group. You are a group. So essentially all you're doing is that you're reorganizing. So why wouldn't you say, I mean, you're a group structure, there is no change in underlying ownership. Indeed, the only reason you're doing all these restructurings and reorganizations is because you just want to change how your group is organized. So yes, on the larger part, the transactions are genuine. It's also true that there might be transactions that are not genuine. And those have been taken care of, again, by the tax laws. That, you have a commissioner who can recharacterize your payments. So we talked about financing considerations. You might have loan notes and all, but if they are convertible loans or something, you might have someone disregard them and say, yes, this one is actually a loan, but we will recharacterize it as equity. Or things like those. Now, those powers, the taxman has. So they have powers to recharacterize. I spoke about the change in control restrictions. You have changed control, and along the way it is noticed that you're actually using it to instead take advantage of tax losses. That will also be addressed, because you will not be allowed to take those tax losses. So it's a regime that is, in my view, quite elaborate. In as far as trying to address any potential aggressive tax avoidance or tax evasion for that matter. I mean, the taxman already has the tools. On the side of the business, you can't fault a business that wants to make the most or try to make the transaction as tax efficient as possible, because at the end of the day, it's business. If you're able to do something within the rules, which benefit the law has actually given you. I'll give you an example. In the Apollo case, Apollo Hotel case, the concession before the High Court, the VAT exemption on transfer of a going concern has a requirement within the law that you must notify within 21 days. Procedural requirements. And the taxpayer did not do those things. But the High Court was able to recognize that may not matter. You can't take away right from this taxpayer who ideally qualifies. Okay? So that's what we are talking about. In the Tungo case, the nutrition case we just spoke about, again, it's a case of why would you want to collect a withholding tax when this transaction under the law will not pay capital gains tax? Are you losing sight of the fact that the withholding tax is actually just an advance payment of capital gains tax? Yeah, so either way, I think there are enough tools. The taxpayers have enough rules within which to play with and make sure their transactions are tax efficient. The taxman equally has enough rules. There are principal purpose, test rules. If the principal purpose of these transactions is essentially to enjoy tax benefits, then the taxman can actually deny those tax benefits. So hope that answers your question, Tony. Thank you.
Thank you, Edward. Our time is fast spent, but there's just a comment from Samuel Kahima. Say, thanks, Balaba. We and URA should start looking at mergers as principally business informed rather than tax informed. We should be encouraging mergers more for their benefits. Look at Airtel, Warid merger, for example. Has it produced more tax benefits or not? Thank you, Samuel. There's a question in the chat. Kindly provide some clarity on the assessment of stamp duty on the transfer of shares I understand that this is based on CPA valuation. However, most CPA issue valuation certificates without even considering the book value of the company, hence incorrect assessments and or underpayment of stamp duty. Is it safe to rely on the CPA valuation certificate?
So quickly to that, so the Stamp Duty Act has a specific transfers of stocks, shares included. The value is not necessarily how much you received or how much you paid. So the value used should be a market value. Now there is a very huge debate as to how that is ascertained. If you talk to valuers, for example, they actually think that that should be work they should be doing in terms of conducting a valuation to determine the value. Now, you can't fault the accountants as well, because valuation is a very interesting discipline. There are so many methods of valuation, and some of those are clearly within the purview of a CPA. A CPA will do a discounted cash flow method based on your balance sheet and determine whether or not they think, there's a certain value for those shares. But the honest truth is that exercise has got to be done. So at its strictest, maybe URSB should even be able to get a report. Of course, they don't. In terms of how did you arrive at the value. Of course, all they want is a form signed by a CPA. But yes, that is the requirement of the law, because the value to be used for stamp duty purposes for stocks like shares has to be a market value and not necessarily the consideration that was paid.
Thank you, Edward. The last question, very briefly. My question is the basis for calling premiums on already issued shares. I understand this option, as opposed to increasing share capital, does not attract stamp duty, especially taking into account that already issued and paid up shares are personal property. Thank you.
So there is a difference. If you looked at financial, you'll have something called equity, and equity can be of different types. So you have your nominal share capital, for example, then you have shares issued at a premium. Now, there is room for debate that the stamp duty, the reading of the stamp duty, which is either on a nominal share capital or on an increase of nominal share capital, should actually address strictly that. Because in terms of how it's reported, you actually have these shares, and these shares carry both a nominal value and a premium value. The premium value of those shares is ideally reported separately from the nominal value of those shares. So to the extent that stamp duty, if one takes the view that stamp duty is, you have stamp duty when you start a company, you have stamp duty when you increase. So you have stamp duty on the initial capital, which is a nominal capital. You have stamp duty on the increase. So whatever you have as increase of share capital should have stamp duty. Now, if your planning is such that the premium value is not part of your increase, maybe you will not pay, but you might land into some problems with the Revenue Authority. But ideally, yes, what we are looking at is what is your nominal value in terms of your shares. Thank you.
All right. Once again, let's appreciate Mr. Edward Balaba. Thank you very much. That brings us to the end of our first session.
Good morning, everyone. I am Fatuma Ramadan Nabulia, a legal associate at Libra Advocates. I welcome you to day 2 of the Tax Symposium, and I'm going to be the chairperson and moderator of the second panel today. Our discussion for this panel will focus on the recent tax decisions that have impacted tax administration as well as Uganda's overall development goals. Joining me today is a distinguished panel of tax experts that need little to no introduction. However, I'll comply with tradition and proceed to introduce them nonetheless. I'll start from my far left. Mr. Oscar Kambona is a founding partner at Kampala Associated Advocates, where he heads the tax department. He has over 20 years of experience in tax practice, during which he has lectured at the Law Development Center. He has been advisor to the Commissioner General of the Uganda Revenue Authority, as well as lectured at the National University of Rwanda. Mr. Kambona holds an LLB and LLM from Makerere University. To my immediate left is Mr. Ronald Kalema, with over 14 years of experience in litigation and tax practice. He is a senior partner and head of the tax practice at AF Mpanga. He boasts of an LLM from Makerere University, an LLB from Makerere University, and an LLM from New York University. Lastly, but by no means least, is Ms. Jackie Aturinda, an associate partner at Birungi and Barata Associates, one of Uganda's leading tax specialized firms. She holds an LLB from Makerere University, as well as an LLM from the University of Cape Town in South Africa. Ladies and gentlemen, we are honored to have you today. Without further ado, I'd like to delve into the topic of today's discussions. Our panelists today are going to share their views and experience, specifically regarding selected tax decisions that have been rendered by the Tax Appeals Tribunal and the High Court of Uganda. The cases span a variety of tax heads, including capital gains tax, value-added tax, as well as customs tax. Starting us off will be Mr. Oscar Kambona, who will take us through the 2 parallel decisions of the High Court and the Tax Appeals Tribunal involving a similar taxpayer and arguably a similar set of facts regarding export services for VAT purposes. To highlight the importance of these 2 decisions, I'll just give a brief of URA's tax collections under the VAT tax head, which have exponentially increased to 4,433 billion in financial year 2023-2024. As URA seeks to hit its targets, otherwise settled principles of law have found themselves before courts for reinterpretation, and no cases explain or illustrate this better than the 2 Allied Beverages decisions. Mr. Kambona, over to you.
Thank you very much, Chair, and good morning, ladies and gentlemen. My task this morning is to share my lessons from 2 decided cases, as the Chair has highlighted. And the 2 decisions, as she rightly pointed, involve Coca-Cola affiliated companies. But the titles of these cases is Allied Beverages Limited which is a standalone company that was contracted by the Coca-Cola Export Corporation in the UK to provide them specifically two services: brand marketing and research services. Now, I'm very mindful of not going into the finer details of these cases, but I'm going to focus on the lessons the key lessons that we need to have at the back of our mind in our tax practice. But to be able to appreciate that, we need to understand some of these underlying facts, because they form the basis on which the decision was made. So Allied Beverages, like I said, is a standalone company and was contracted by a Coca-Cola company in the US to provide those two services. It provided those services and invoiced for those services, but did not charge VAT, on the understanding that this was an export of services. So the moment you export services under the VAT law, it's zero rated. The question was this an export of services? To the taxpayer, it was an export of services. To URA, it was a local supply, and therefore should have attracted 18% VAT. Now, the issue was, when is a service deemed to have been exported? The law provides, under the VAT Act and the regulations, that if you provide a service that is consumed outside Uganda, then that service is deemed to have been exported out of Uganda. So, it sounds easy, but the question then is, what is consumption outside Uganda? When is the service deemed to have been consumed outside Uganda? Remember, we are dealing with a service. It is not a good, for example, where you can say this specific pen has been exported and you can understand that it has been consumed or used outside Uganda. You are dealing with a service here. So the point of contention, as far as the taxpayer is concerned, is that these services, which included research services, were utilized by the company that purchased the services in the US. URI's argument was that no, some of those services were actually performed in Uganda and were utilized by affiliate Coca-Cola companies. Remember, there is Century Bottling Company here that produces the Coca-Cola, not part of this dispute, but it's affiliated to the Coca-Cola companies. So the argument was that whereas you have Coca-Cola US, different from Century Bottling in Uganda, the service that was being contracted in this transaction was going to benefit Century Bottling in Uganda. So to that extent, there was a mix of benefits. Now, fast forward. This matter, of course, the taxpayer objected, and this matter went to the Tax Appeals Tribunal. The Tax Appeals Tribunal ruled against the taxpayer and in favor of the URA. The basis of their decision was strictly that the service was being performed in Uganda. That was their argument, number one. Number two, the taxpayer during the presentation had also introduced the OECD, what they call the destination principle in the OECD. OECD guidelines provide that where the service is used in another destination, that is the basis on whether there has been an export or not. So it had a destination principle. And the question was, do the OECD guidelines apply in Uganda? And I'm raising these issues because they are very critical and they are very topical issues that are controversial as far as taxation is concerned. So the tribunal ruled the service was performed in Uganda. 2, that OECD guidelines don't apply to Uganda. 1, that Uganda is not a party to the OECD guidelines, and 2, that Uganda is not in Europe, and therefore those rules don't apply to Uganda. Now, I will reserve my comments, but I just have to mention that there was an appeal. And that appeal is the one that I am now discussing as the first case. The taxpayer appealed to the High Court. And the taxpayer's argument was simple. 1, the issue of performance is irrelevant. Where the service is performed is irrelevant for purposes of exported services. And then 2, the argument that OECD guidelines are actually persuasive. They may not necessarily be binding, but they are persuasive. In other words, if they are not in conflict, then they are applicable. Now, this decision from the Commercial Division by Lady Justice Magara, Harriet Magara, ruled that 1, performance is irrelevant. What is relevant is consumption. Again, that's where I started. And the argument of the judge was that a service is consumed depending on the nature of the service in issue. In particular, here we are dealing with research. So the question was, if someone does research in Uganda, makes a report and sends it to me in America, and I go into a board meeting, and the board meeting reviews and considers that research report, where is the consumption? The consumption has been in the US. Where that report has been, it sounds, again, easy. The question is, when the board makes a decision and sends, and the impact of that decision is implemented in Uganda, where is the consumption? The consumption then becomes Uganda of the sole consequence. I bring that up because that then became a dispute again before the Tax Appeals Tribunal in the second case. So there are 2 cases. One came through the tribunal and went to the High Court, and the High Court ruled in favor of the taxpayer. Now, URA, in another financial year, the next financial year, decides to raise an assessment and says, now, this is a new financial year. We have raised an assessment for this amount of money, raises, and the taxpayer objects, and the taxpayer now goes to the Tax Appeals Tribunal. So you then have a new case against URA by the same company called Allied Beverages. Same facts, same everything. Now there's a new argument that comes in. The argument then is, you are actually using services and consuming them in Uganda, and that those services that we are dealing with include advertising, which took place in Uganda. Now, I remember I mentioned one of the services was brand marketing. So what happens is that the uniqueness of this case is that this company in Uganda, Allied, would give the research to America, and America, which was in charge of producing concentrate, and maybe to clarify this, concentrate, Coca-Cola here in Uganda, only it's called a bottling company. The actual concentrate, the actual solution that Coca-Cola has is produced somewhere outside Uganda. These companies import that concentrate and make this bottle, this Coca-Cola. That company in the US is the one in charge of producing that concentrate, and that's its business. So the company's argument was that we contracted this company to do brand marketing so that the concentrate we are producing is consumed more in Uganda. Again, like I said, I reserve my comments on the interpretation and the conclusion. But let me go to the holding of the tribunal. The tribunal has now ruled that actually this consumption is in Uganda. It has ruled that it is consumed in Uganda by the company that contracted these allied beverages. And that because of that, the consumption has happened because consumers in Uganda see the adverts, do everything, and consume Coca-Cola in Uganda. Now, you will read the details. But for me, what are the lessons? What are the key lessons? Let's unpack the key lessons. Lesson number one is that this whole issue about services is what you call a question of fact. So we are moving taxation not necessarily only on points of law, but also in terms of fact. So evidence. What evidence are you producing, and how do you explain the circumstances of this case? Mr. Kalema actually asked me a question here and said, who consumed this service? Is it the man who drinks the Coca-Cola, or is it the person who contracted for the research services in? So it's a question of fact, and you can see how fact affects the outcome of your decision. So that's the question that I see that we need to have at the back of our minds arising from this decision. But quickly, number two is an issue that I find very topical. When is an assessment which has been decided upon by court conclusive and binding on other years? Because like I've said, these are same parties, same facts, same everything is the same. What is different financial year. So when will there be conclusion of issues? So now you have the taxpayer appealing back to the High Court, and then you have the URA in the High Court also appealing against the High Court decision to the Court of Appeal. The question I ask, does it mean that even the other financial year they can decide to raise another assessment? So this is a topical issue that we need to have at the back of our mind. Then quickly is the issue I find very important, OECD guidelines. These OECD guidelines, I mean, in Kenya, decided cases have ruled that OECD guidelines are automatically applicable. Uganda is still a slippery area. And I say slippery because, yes, the court ruled that the OECD guidelines are applicable, but from a persuasive standpoint. I still believe that we cannot be an island as far as international taxation is concerned. As long as you have got transactions that cross borders, we are definitely and inevitably having to be in a position to look at what happens in other jurisdictions. Yeah, and that concludes my point that even as commerce and trade progresses, we are going to have more complicated issues. And it's high time that we as practitioners, we as people in the tax arena, address this advancement in technology. whereas it may be easy to even look at issues of a report in hard copy, what about with this IT revolution, the digital revolution, where it will be difficult to see the physicality of the service? So the takeaway really is that that these decided cases have brought in interesting concepts, but they have also brought in very interesting controversies. And I conclude the controversies with the fact that when is the High Court decision binding on the Tax Appeals Tribunal? At what point will you say a higher court? We in the common law, and Uganda, we operate the issue where a higher decision binds a lower decision. But now, of course, the tribunal in the decision mentioned that they were distinguishing facts, that the facts were slightly different. But I'm saying these are same parties, same transaction. It's your interpretation that may be different of those facts, but the facts may not necessarily be different. And of course, we are alive to the problem we had with 30%. You remember 30%, the Supreme Court ruled that it is constitutional. You then have the Court of Appeal ruling in Fuelex that it is not constitutional, although making some qualifications. So, I mean, for me, the takeaway is that we need to work as a society, and we need to emphasize the aspect of consistency. We need to certainty of matters and conclusiveness of disputes. This is my takeaway from those two cases. Thank you.
Thank you very much, Mr. Kambona, for that insightful discussion. I'd like to recognize the presence of Mrs. Stella Nyapendi Chombo, an honorable member of the Tax Appeals Tribunal, and Mr. Andrew Chambade, a partner at Godena Associates. We are coming to you, Mr. Kalema, specifically to discuss the case in Tunga Nutrition versus Uganda Revenue Authority. Yesterday, during the Honorable Chairperson of the Tax Appeals Tribunal, during her presentation, she emphasized the need of tax and tax practitioners on both sides of the aisle to adopt a human face to transactions, to ensure that tax practice and taxation works for businesses and for the promotion of businesses and investment in Uganda. One of these realities is corporate reorganization that Mr. Balaba briefly hinted on, but one that is discussed in this case of Tunga Nutrition versus Uganda Revenue Authority. Mr. Kalema, could you please take us through the crux of the dispute as well as the reasoning of the Tax Appeals Tribunal?
Thank you very much, Fatuma. Good morning, everyone. The Tunga dispute started with a transaction, with an M&A transaction in 2022. Tunga was a company, Unga Millers was a company that needed infusion of capital. So they found themselves a partner. That partner was Nutreco. Nutreco is a Netherlands-based company, and they agreed to form a joint venture whereby one party contributes cash and know-how, and then Unga Millers would contribute assets, and then the local know-how and access to the market. So in 2022, they entered into an investment agreement to invest jointly, and that is how Tunga Nutrition came into being. Tunga is essentially a joint venture business between Unga Millers and Nutreco. So as Edward was discussing here, both taxpayers thought through the tax consequences of the way they would organize their joint venture. And eventually they decided that forming another company into which UNGA would contribute assets rather than cash is the most tax efficient and would qualify for rollover within the meaning of the law. So tax was at the forefront of the transaction from the get-go. One of the reasons they decided to go that way and not to do an outright asset purchase was the tax benefit of that form of M&A. So Tunga does an asset transfer agreement. It clearly states that in exchange for 50% of the shares, they would give Unga Millers, 50% of the shareholding. In exchange, they would get Unga's assets. At that time, taxpayer applied for a private ruling from the URA. Up to now, that private ruling has not been given, so we can safely say it has been overtaken by events. But what happened next was, in transferring the land, there was a stamp duty declaration. Now the land was being transferred from Unga Millers to Unga. Stamp duty, as you know, for land, you go to the government valuer, they give you the value, you pay the stamp duty, you transfer the title into your names. That's what Tunga did. Now, URA, based on that declaration, to assess withholding tax. Essentially, they were telling Tunga, you purchased these assets, you did not withhold 6%, here is the assessment, in accordance with section 118 as it was then. I think now it's 132. When the matter came to objections, essentially there were two arguments. That firstly, you can't use the stamp duty declaration. That's not what I paid. In fact, I didn't pay anything. I just issued shares. Stamp duty is the government value. I have no control over that. Secondly, this transaction qualifies for rollover relief because in exchange for these assets, shareholding of 50% was issued. Both companies are residents, and there is no reason why you can now use withholding to tax the transaction because it is deemed not to be a disposal for tax purposes. When the objection decision came out, URA's position was essentially not that the basis of the objection decision was that you do not qualify for rollover. And the reason was the land was transferred at an amount that is higher than the cost base. The 10 billion, you remember the stamp duty declaration. Remember in section 76, there is wording to the effect that the transferor and transferee essentially exchange the same cost base. So since a declaration had been made for stamp duty purposes that the value of the land is 10 billion, you do not qualify for rollover relief. That was a tacit agreement that if I qualify for rollover relief, then the tax would not be applicable. So the matter moves to the Tax Appeals Tribunal. When the matter moves to the Tax Appeals Tribunal, essentially Tunga presented the same arguments. And the key argument, and which I feel was not addressed by the tribunal, when you read section 76.1, section 76.1 in my view is the least problematic to apply. It doesn't have a lot of complications like 76.2 and 3. 76.1, both taxpayers must be resident. You must transfer a business asset. In exchange, you get shares, you get a controlling stake in the transferee. Once those are fulfilled, then you apply the consequences. No gain, no loss recognition, cost base the same for both taxpayers. So what URA had seized on, the language in section 76, where a resident person in this subsection referred to as a transferor transfers a business asset with or without any liability not in excess of the cost base of the asset. The problematic words were these ones, not in excess of the cost base. So to what does not in excess of the cost base apply? Because remember, there are words that were omitted here. The asset, the business asset, must be with or may be with or without a liability. So does not in excess of the cost base refer to the transfer value, or it refers to the liability that is preceding the use of the words not in excess of the cost base? In this transaction, there were no loans or mortgages attached to the asset. But you may find cases where, for example, the land had a mortgage. And the mortgage, let's say the cost base of the land is 200 million. Land was acquired 10 years ago. Its value is now 3 billion. It has a mortgage of 1 billion. How would we then apply this transaction? Because there is a restriction, to my understanding, that the liability attached to that asset must not be in excess of the cost base. So does the taxpayer get thrown out completely, no rollover relief, taxes paid, or do we limit the application? Do we limit how the liability affects the whole transaction? That's not how URS saw it. And when the ruling came out, I noticed that's also not how the tribunal saw it, although ultimately, in my view, the correct conclusion was reached. So in the ruling of the tribunal, they listed conditions for rollover relief. A resident transferor transferring a business asset to another resident transferee, the business asset not in excess of the cost base was also listed as a condition in exchange for 50% shareholding. So, lucky enough for us, we had presented the tax returns of both Tunga and Unga. And what the taxpayers had done, the transferee had inherited the written down values of the transferor for the other assets. But you may have assets, for example, land, where if you go to the taxpayer's return, nowhere does it ask you to give the cost base of that land. There's no provision for that. How do you show it? So the only thing we had to show was, yeah, this is not a condition, but we fulfilled it anyway because the written down values of the depreciable assets of Unga and Tunga were the same. The same for the IBD, for the buildings, the building allowances. The closing balances of the transferor became the opening balances of the transferee, which meant that at any future time of disposal, that gain would be taxed at that point because it would be much larger. The transferee doesn't get a step up in cost. Other fringe arguments came up during the trial that, your company was incorporated in 2021, the transfer happened later, so how did you pay for the shares with the subsequent transfer? But thankfully, the tribunal ignored those ones because, as you know, you can have paid up and unpaid up shares. And then the other fringe argument was there was no valuation of the shares and the land. In the transfer agreement, the share is a different value than the actual nominal value of the shares. And the tribunal found that there was no need to do a valuation because the numbers that are taken into account for purposes of Section 76 are tax numbers. Yes, so for purposes of capital gains tax, what would happen now if Tunga were to dispose of this land? They would take the cost base at which Tunga acquired the land in 2011 or whenever, when calculating the gain at the future time of disposal, taking it off the value of the consideration they would receive at that point. So naturally, I was very satisfied with the ruling, but I have to say there is an appeal. URA has appealed this decision, so we await further battles in the High Court. Thank you.
Thank you very much, Mr. Kalema. Our third case is going to be discussed by Mr. Trinda, and to provide a brief background and highlight the importance of this ruling, it is important that we go back to Uganda's development objectives, specifically Vision 2040, which highlights that its central theme is a transformed Ugandan society from a peasant to a modern and prosperous country within 30 years. And to achieve this, Uganda is looking at growing its infrastructure network rapidly, which, as we all know, local capital cannot assist in. So Uganda often finds itself looking to foreign capital to spur its growth and implement its development objectives. Mr. Trinda, in your discussion of Kalangala infrastructure versus Uganda Revenue Authority, I'd like you to highlight the importance of this ruling, specifically towards Uganda's development objectives, and whether you think that it is a ruling or that its opinions were a step in the right direction. Thank you.
Thank you very much. Good morning, everyone. Yes. The case of Kalangala Infrastructure Services versus URA stems from Kalangala Infrastructure Services entering into a PPP with the government of Uganda, like the moderator has mentioned, to develop infrastructure in Kalangala at the island. So Kalangala sought financing through debentures from Nedbank South Africa of $12 million. So Nedbank was not able to raise that amount of capital and sought assistance from Emerging Africa Infrastructure, which I'll refer to as EAIF during this discussion, for the top-up after the 5 million, the 7 million. So Kalangala Infrastructure Services paid the interest relating to that loan and did not withhold, declared the interest as exempt in the returns. So the taxman assessed Kalangala Infrastructure Services, saying that they did not withhold, but specifically on the loan from EAIF, not the one from Nedbank. And the argument was that that loan was not widely issued. And Kalangala objected to this assessment on the basis that the interest paid to EAIF was exempt from tax under Section 83.5, which is now 82.5. If I could just go to what it says. It says that interest paid by a resident company in respect of debentures is exempt from tax under this act where the following conditions are satisfied. Debentures were issued by the company outside Uganda for the purpose of raising a loan outside Uganda. The debentures were widely issued for the purpose of raising funds for use of the company in a business carried on in Uganda. Or the interest is paid to a bank or a financial institution of a public character, and the third requirement is that the interest is paid outside Uganda. The applicant's position, that is KIS's position, was that these debentures were clearly issued outside Uganda, in South Africa, and in Mauritius. Also on condition number C was not in dispute because clearly the interest was paid outside Uganda. The dispute was on where? On B, where the taxman was saying that this debenture was not widely issued. The reason they were saying it was not widely issued was because it was limited to infrastructure development. So the applicant's argument was this particular condition has two limbs. One, it is either widely issued or it is interest paid to a bank or a financial institution of public character. The respondent along the way stepped away from the argument of widely issued and now stuck to public character. Again, saying this financial institution, EAIF, does not meet the public character test because it is limited to infrastructure development. The tribunal found that it meets the test of public character, and if you look at the practice note of July 2006, it defines public character to mean that the benefit provided by the entity must be to the public at large or at least to a sufficient section of the community. EAIF gives loans for infrastructure development in different countries in Africa, not necessarily just Uganda. So KIS was among the beneficiaries of those loans that are given. And including Senegal, Cote d'Ivoire, Kenya, Rwanda, they've given to all that. So the tribunal found that it meets the public character test. So the taxman restricting it to it just being infrastructure, the taxman actually was saying that it should be open to anyone in the public, not just infrastructure. And the tribunal's decision was that the fact that it is open to any country, any person, or any entity engaged in infrastructure development, it meets the public character test. And the tribunal in that decision went ahead to say that it is one of the reasons the national development goals and to bring in more capital into the country to support these infrastructure developments and also develop the country as a whole. In addition to this decision, the respondent was saying that this entity is not a financial institution. And when you go to the Income Tax Act, it defines a financial institution. And if you go into the nature of the work that EAIF does, it gives loans, it gets financing from its partners, development partners, from the public, which fits within the definition of the financial institution under the Income Tax Act. So the tribunal's findings were that the applicant raised the loan outside Uganda by issuing loan notes to EAIF, a company based in Mauritius. Therefore, the applicant satisfied the first condition. Then EAIF is a financial institution, as earlier mentioned, and that the interest was paid to Nedbank, a company based in South Africa, which was passed on to EAIF in Mauritius. Therefore, interest was paid outside Uganda. The tribunal concluded that EAIF met all the conditions under Section 82(5) of the Income Tax Act, not liable to the withholding tax. KIS was not liable to the withholding tax assessed, and that assessment was set aside. But like everyone else here has mentioned, this decision is on appeal in the High Court. And the implication of this decision is that it clarifies the definition of financial institution of public character. And it also confirms that infrastructure projects such as these are encouraged in the country by giving them such incentives or exemptions to invest into Uganda and also for our development. That will be all for me.
Thank you very much. Our next decision illustrates the Tax Appeals Tribunal's duty and power to check URA's discretion, specifically regarding issuance of withholding tax exemptions and how far URA can go in revoking the same. Mr. Kambona, if you could please do us the honor of discussing Cambon Building and Electrical versus Uganda revenue authorities?
Thank you very much. Perhaps I should start by saying that, well, in politics, you are either on the right or you're on the left, but now there's another category of the progressives who are in the middle. So you are either a conservative or you're a liberal or you are now a progressive. Why do I raise this categorization? Is that the Tax Appeals Tribunal now, in my view, is in the middle. It's progressive. It's a progressive, the way they are looking at things. We've had situations where the tribunal was conservative. And now I think they are liberal. Why do I say that? This decision confirms that. This decision of Combo, and perhaps maybe I should recognize the member, Stella, who is here with us, and appreciate that you are here and the progressiveness of the tribunal. This is a case. Combo Building and Electrical applied for a withholding tax exemption. The law is very clear. URA has got a discretion to give you that exemption or not. It's their discretion, no doubt about it. URA exercised the discretion and granted the exemption. To that end, everything is okay. Shortly after, without the knowledge of the taxpayer, URA cancels. It did not notify the taxpayer. The taxpayer did not give what we normally know in law as objection. There was no chance to give an objection. And interestingly, there was no decision in writing. The decision was in action of the list. The taxpayer decides to challenge that decision in the Tax Appeals Tribunal. Now, for me, the reason I started by saying it's progressive, because the question is, you must be a progressive tribunal not to ask for a written decision. You must say, but we've had circumstances where say, but where is the decision? But secondly, the progressiveness is in how the tribunal interpreted and resolved this issue. The tribunal then said that, yes, URA, you have that discretion. Yes, you have also a power to cancel. You can cancel that. Whatever I give you, if you misuse it, I will cancel. But where is the fair hearing? Where is the ability for me as a taxpayer to present my case to you? They ruled that they had fallen short on that aspect. But interestingly, and more importantly, they brought up the principle of legitimate expectation. And I think for me, that is the progressiveness of the thinking. Legitimate expectation is purely you, a public body, has led me to believe that I'm going to enjoy this. And I have acted on that belief. And you have now changed your mind. What it is saying, legitimately, I should expect you to honor what you gave me until it expires. Legitimate expectation had been raised in several cases in the Tax Appeals Tribunal before. I think in 2001, in 2010, tallow oil had been given an assurance by government in 2008 that when you sell your shares, you will not pay capital gains tax. Government changed its mind and said, no, the one who gave you that power was a minister of energy, not minister of finance. Anyway, The taxpayer says, but you assured me. So I legitimately expect the tribunal then, like I said, conservative, said, but it's the law. Look at the law. Fit within the law. So we are seeing a shift here, and I think for me, rightly so. You are seeing a shift where someone is saying, yes, you promised me something, honor it. Especially if I honor my part. If I make a mistake, that's a different matter. If I do not comply, that's a different matter. But as long as I comply and I honor my part, honor your part. That's what the tribunal has now ruled, and that's the decision. So, A, you have power to give withholding tax. B, you have power to revoke. But C, where you grant, you cannot unilaterally revoke without not giving me a chance to defend myself. And also, an interesting area where decisions are made which are not communicated in writing, you still have room now to challenge such decisions. I think for me that is important. I've had taxpayers come to me and say, you know, my TIN has been blocked. Some taxpayers come to you and say, but the question is, what is the basis on which I can challenge? And I think for me this helps in that regard. Thank you very much.
Thank you very much, Mr. Kambona. I think it is safe to say that the tribunal's upholding of the principle of legitimate expectation aims to create certainty amongst taxpayers and facilitate proper tax planning. Our next case acknowledges the multifacetedness of humans and people. It draws a distinction between business affairs as well as private affairs. It has distinguished that even renowned businessmen are not businessmen at all times. It has acknowledged that in some cases, they are private individuals like all of us here. And this case is Dr. Amos Nzeyi versus Uganda Revenue Authority, where he challenged a capital gains tax assessment on a sale of land that he argued was of a private nature. Luckily, we are here with Mr. Kalema, who is well versed with the intricacies of the matter, and I believe will be pleased to take us through.
Yeah, thank you, Fatuma. These days when I'm passing on the Entebbe Express Highway and I see the Pepsi factory there on the side, I say, thank God, thank God. So if you've seen the Pepsi factory along the Express Highway when you're going to Entebbe, that was the land that was the subject of this dispute. So the taxpayer in this case purchased the land in 2010 and transferred it into his own personal names in 2012, and then waited for a total period of close to 9 years. Now, Crown Beverages started looking for land to build that factory, and who to buy from other than the person who you know very well. So he sold the land to Crown Beverages, and Crown Beverages reported that transaction in their returns and books of accounts, and that's how URA gets to know about it. So assessment comes out, more than 2 billion shillings. Taxpayer objects and says, this is my private land, it's not a capital gain. And we go for objection meetings. Now, the most interesting thing for me during the objection was that this particular taxpayer was being assessed because of his reputation as a businessman. because you would get comments like, but why else would somebody buy 40 acres of land? For what? Of course you are in business. Of course he intended to sell it and make a profit at a future date. Why did he buy 40 acres of land? We never answered that question, but we said according to the law, this is land that was held in his individual capacity, and therefore it is exempted. So the matter moves to TAT. When the matter moves to TAT, you remember in the June 2024 cycle of amendments, there was a proposal to tax 5%, impose a 5% tax on land in towns and municipalities. Do you remember? That proposal failed. That land was in towns and municipality. It is in a municipality. So for us, that bolstered our point of view that currently privately held land is not subject to tax. When the matter moved to court and now URA had to disclose what the basis of assessment, the first basis of assessment was this taxpayer is in the business of buying and selling land. Therefore, he disposed of his trading stock. That piece of land is his trading stock. There was no official disclosure that he's a renowned businessman. I want to make that very clear. That was... Yeah. So, when the matter moves to court and the trial starts, the argument from the taxpayer was quite simple and straightforward. This is a private asset, whereas you may think that I have all these other assets. I am not in the business of buying and selling land. But from the point of view of me or you as a practitioner, remember the evidential burden is on you as a taxpayer. Now we had to think through how to prove or how to show to the tribunal that this taxpayer is not in the business of buying and selling land. How do you prove a negative? If URA is saying I'm making income as a night dancer, how do you prove that you are not a night dancer? I remember my team asking me that one. So in our submissions, we elaborately said, it's not on us to prove a negative fact. If the other party is alleging that the taxpayer is in the business of buying and selling land, they should be the one to adduce the evidence. I should not be required to prove a negative fact. So all we could do is to produce evidence of the sources of income of the taxpayer through their return. They have shares, they get paid dividends, they file their returns on time, they have rental income. On the side of URA, the evidence that was produced was the taxpayer's profile. When you are registering your TIN registration, they ask you where do you get your business, your income, which sector are you? Oil and gas, real estate. You are supposed to check that box. Now the taxpayer, since they have rental income, they had checked the box of real estate. And for them, that was enough. That you've told us on your profile that you are in the business of real estate. That shows us that you are in this business. The tax is due. Interestingly, no issues of VAT came up. No other issues came up. This is the only way they chose to attack the transaction. So the tribunal in its ruling, and I would agree with Oscar that this is one of those progressive rulings, held that this is indeed, the capital gain is only due on business assets, and business assets are those assets that are held in a business, and in order to determine whether the taxpayer was in the business of buying and selling land or whether this was an adventure in the nature of trade, they looked at a few badges of trade. Did you improve the land? Did you make improvements? The answer to that was no, the land was a bush. How long did you hold the land? 9 years, which means it is not someone who holds trading stock for 9 years. That is not a person who is in trading. Did you set up any office? Did you advertise? No, none of those facts were applicable. And in the end, they held that a tax checking a box on your profile is not enough to prove activities. So what I like about this decision was the tribunal's insistence that URA's evidence was not enough to justify the assessment. Most of the time, what the tax authority will do is make an allegation, and then it will be up to you to disprove it. But in this case, I think the approach was URA is not a passive participant. If there is an allegation made, they have to prove it. And in this case, not sufficient evidence was produced to justify the assessment. Thank you.
Thank you very much, Mr. Kalema. Before we head on to our last case, for our colleagues joining online, in case of any questions, those can be put in the chat. We'll have a Q&A segment at the end. Then we are going on to tropical heat versus Uganda Revenue Authority, a case basically challenging URA's calculation of import duty and highlights the importance of sequencing the classifications under the East African Community Customs and Management Act when calculating import duty ad valorem. Ms. Atrinda, the floor is yours.
Thank you very much. The issue of valuation of imports has been in our courts for a very long time, and it is something that is very common with the customs department here. Even when the topmost court pronounced itself on the primary valuation method being the transaction value method, the taxman has time and again done this. They will keep skipping the transaction value method to probably the last one without clear explanation as to why they have to move from the transaction value, which is the primary method provided for in the YACMA, and also all courts have pronounced themselves on that. So in the case of tropical heat, we've all seen tropical heat goodies and spices in our supermarkets. Tropical heat purchases is a subsidiary of Tropical Heat Kenya, and it's 99% owned by Tropical Heat Kenya. So Tropical Heat Uganda purchases goods and declares the goods and pays the tax using the transaction value. So for this particular assessment, Tropical Heat had used the transaction value method and paid the taxes. URA audited and used the fallback method, which is the last method. And like she had highlighted, it is a sequence. You have to start from the first one to the next until the sixth. And URA's position was that first is that Tropical Heat Uganda receives discounts from Tropical Heat Kenya. It also said that they had a TPP which was outdated. And the applicant's position was that discounts are part of, it's a normal business thing. Anyone can give discounts. And these discounts were open to all their clients, all the clients for Tropical Heat Kenya. They provided invoices, they provided purchase documents to show that actually some countries, like Rwanda, receive something higher. They receive 30%, when Tropical Heat was receiving, I think, about 23% of the discount. So the tribunal, looking at the IACMA and definitely the evidence provided by the parties, first of all, the applicant's case was that the trade discounts were offered by their supplier at arm's length because similar trade discounts were offered to non-related parties. Receiving trade discounts was standard commercial practice, so it was open to anyone. It was not just limited to tropical heat Uganda. The transaction value of the imported goods closely approximates the tax value mentioned in the provision of the law. It was not outside the law. The TPP between the parties is at arm's length, and it was not giving any benefit to tropical heat Uganda. The respondent applied the fallback valuation method without justifying why other valuation methods were inapplicable, in contradiction with the law. The relationship between tropical heat Uganda and the supplier did not influence the price actually paid or payable. URA stated that the applicant and the supplier are related entities. Like I'd mentioned, that Tropical Heat Kenya owns 99% of the Ugandan entity, and the applicant shares that due to the relationship, the prices at which the applicant purchased the goods was influenced by that relationship. The discounts were not standard trade practices, but were intended to uniquely benefit the applicant, suggesting a non-arm's length arrangement. Then again, that the review of the TPP indicated that parties were not trading at arm's length as specified in the policy. The policy was outdated and could not confirm the reliability of the comparable companies used. The tribunal's finding, first, the question that the tribunal was determining was whether the URA was justified to reject the transaction value method and apply the fallback method in determining the customs value of the imported goods. So relying on section 122.1 of the IACMA, which mandates a sequential application of 6 methods of customs valuation, starting with the transaction value method. The tribunal found that subsequent methods can only be used if the value cannot be determined under the preceding method. Transaction value method is the primary method based on the price actually paid or payable to the goods sold for export. However, where the buyer and seller, this is when the parties are related. As in this case, the transaction value is acceptable only if the importer demonstrated that the relationship did not influence the price or that the transaction value closely approximated certain tax values. The existence of the relationship does not automatically disqualify the transaction value. It can be accepted if the relationship did not influence the price or if the transaction value closely approximates it. The tribunal also found that discounts may be acceptable for customs valuation purposes as long as those discounts are uniformly available to all and based on logical commercial basis. Like I earlier mentioned, these discounts are open to buyers, to entities that purchase or buy from tropical heat Kenya. So it's not limited to tropical heat Uganda. So the tribunal found that the respondent failed to demonstrate that the discounts were non-commercial or uniquely favored the applicant in a matter that influenced the price beyond what could occur in an arm's length transaction. It also found that the respondent was not justified to deviate from the primary means of customs valuation, and held that the respondent was not justified to reject the transaction value method and applying the fallback. So the implication is the law mandates a sequential application of the valuation method. And this is a confirmation of what has been restated over and over by the courts, that the primary valuation method is the transaction value method. Again, this promotes certainty, especially for international trade, by emphasizing compliance with the IACMA and sequential methodology.
Thank you very much, Ms. Atrinda. Another decision from the Tax Appeals Tribunal acknowledging the economic realities, not just what is stated under the law, because URA's argument was that these are related parties, so automatically there has to be some sort of benefit derived. but the tribunal goes ahead and investigates and finds out that economically there isn't much that they are deriving from being related to tropical heat Kenya. Mr. Kambona, that same argument was fronted by the Tax Appeals Tribunal in the second Allied Beverages case, where the tribunal noted or relied on the economic substance and the economic realities of the transaction, were holding that, yes, the parties are Allied Beverages and an American entity, but as far as the tribunal is concerned, the consumption is being done in Uganda because you and I, who are being influenced by these advertisements on local channels, those were deemed to be the final consumers of the service, and hence the tribunal held that consumption has been done in Uganda, so it is not an export of services for purposes of VAT. Which brings us to a question by Ms. Charlotte Katutu, because the tribunal refrained from relying on the High Court decision in Allied Beverages, the one by Honorable Lady Justice Magala, and instead chose to rely on Elma Philanthropies. So Ms. Katutu asks that please comment on the tribunal's reliance on the decision of the High Court in the Elma Philanthropies case, which was subsequent to and divergent to the High Court decision in Allied Beverages. Yes.
Thank you very much. Like I said earlier in my first presentation, I tend to keep back from passing my personal judgment on the soundness of a decision by a court, because we are all entitled to our own opinions. The way I look at things may be different from the way you look at things. The way I perceive or listen and interpret the evidence is different from the way you look at it. So to that extent, disagreeing is healthy, because there is a forum what to do after that, and that forum is you appeal. You go to the next court, and the court looks at it afresh and looks at and makes a decision. With that context, my problem is one. My problem is that you can disagree on interpretation of facts, but you cannot disagree on facts being what they are. Is this a pen? It's a pen. What it does is different. I can use it for decoration, I can use it for writing, that is different. But is it a pen? That one, you're not entitled to your new facts. Why am I giving that background? Elma Philanthropies disagreed with Coca-Cola. The judge, both were High Court decisions. They disagreed on facts because these were two different facts. The judge in Elma interpreted the facts in that particular case and came to a different conclusion. There is a difference in facts and in law. What am I saying? Remember, when I was discussing the first case in the tribunal ruled that this was not an export of services because performance was in Uganda. That is a point of law. Is it a question of where performance happens, or is it where consumption happens? When the Court of Appeal, the High Court disagreed and overturned that, it ruled that consumption is the most important, not where performance is. Elma does not disagree. Elma does not say it is where performance happens. Elma is saying where consumption happens. What they disagree is whether consumption actually happens in Uganda or outside Uganda. So it's a question of interpretation. Now, you raise a very important preamble where you said that In Elmer, the judge was saying, let's look at the substance, let's economic effect. I mean, it's the argument we've always had before. The difference between substance and form. And I mean, this is not rocket science. At the end of the day, you want the meat. You want to look at the meat. What is the intention? If I sign a contract and say, I'm entering this understanding on this, when in actual fact it's different. Should you be bound by what you put in your agreement? They will be bound by actually what is on the ground. So yes, again, you said it was Katutu? Yes, Charlotte. Katutu is right. There was a distinction, there was a disagreement within the High Court among the judges. They ruled differently, but they did not disagree on whether it is a question of consumption. And two, I agree that we must always look at the substance. I think there are several cases, even Court of Appeal cases, which talk about substance over form. But thirdly, I end where I started. I end by saying we need consistency. Where a High Court judge disagrees with another, it's allowed. The law allows it. The law allows a judge to depart from what a colleague at the High Court says. What the law does not allow is for you to disagree with your superior court. That is not allowed. You cannot say, me, I disagree with you. Wait, you make your decision, let it go to the same court. And I think, without frogging the horse several times, the FuelX project, Uganda project's case on 30%, you can imagine the difficulty we as advisors have got to face, where someone is telling you, but by the way, there is a decision of court, which was later, when you use that analogy of later, which was later to project implementation, which was saying that there is no 30%. But it is later, but the other one is the superior court. One is Supreme Court, one is Court of Appeal. And I think that's why the tribunal has also been having an issue. Because you have these two seemingly contradictory decisions by two different courts saying the different thing. So, yes, the long and short of my submission is that, yes, Elmer disagrees, reaches a wrong decision, but does not disagree on the principle on what is an exported service which is based on consumption rather than performance. Thank you.
Thank you very much, Mr. Kambona. So we open the floor up to the audience. I don't know if there are any questions for our panelists.
Hello? Thank you, presenters, for your analysis of the cases. I wanted to give something alternative in respect of some of the cases. I will begin with Amos Sinzei. Now I'm trying to pose questions without breaching the sub judice rule, since there is an appeal. Now, Mr. Kalema, regarding badges of trade that all of us are conversant with, and those common cases of, let's say, routledge, where someone goes to Europe and buys 1,000 rolls of toilet paper, and there it's taken that, no, you can't use 1,000 rolls of toilet paper too. That is an adventure in the nature of trade. Then you have cases, let's say, of Fraser. You buy 20 tons of whiskey, and they say, no, that whiskey is too much. You can't purpose. Even if you spend your entire lifetime and reach 200, you can't finish it. So it's an adventure in the nature of trade. Now, related to Amos Sinzei, okay, maybe you're blessed, but How many acres were they? 40 acres of land on Entebbe Road. Okay. They had not made the road, but 40 acres of land. I find it, when I relate to the badges of trade and I pick out that item of quantity, I don't know, maybe because I'm biased, I feel like sometimes the asset you have, because of the quantity, you wouldn't fault someone for thinking that that is an adventure. What are you using, ideally, 40 acres of land, if it's not an adventure in the nature of trade? And considering the other assets he has that we are all aware of, but they are not part of this case, but we have taken judicial notice of. So that's where I'm like, this is more of a business asset. Then secondly, and this is on the other aspect, if you read the case of Bernard Byamukama versus Pomwanga, the one of Polo, also that plot of land incidentally is on Entebbe Road after FDC. But Justice Mubiru also talks about when he's defining a business asset, he makes pronouncements, and in his interpretation, he concludes that if an asset is owned by an affiliate, it should ideally qualify as a business asset. Now, this was not addressed by TAT, but I think it's known that Amos Nzei has interests in Crown, has interest in, okay, whoever he sold the land to. Can it be that you as a shareholder, the land you have, you're selling it to the company? And don't you think that also tilts it towards more of a business asset? Because ideally you sat in a boardroom, you bought shares, and you're using this asset to paint it. So those are the points I wanted you to maybe, they were not considered, but maybe if you can address badges of trade and the fact that transactions between affiliates, ideally, if they are assets, and one is engaged in business, it means you're holding that land ready for use to sell it to your business. Then thirdly, if on your taxpayer profile you ticked real estate, I understand the argument is that the way it was structured, there was no box for, you could only, the closest to rentals or maybe real estate, but there was also others though, you could tick others and you type in, but you chose a box. You could have, so you ticked real estate and you are a basis on the fact that on your own declaration that it's real estate. Now, using other concepts, let's say contra preferendum, isn't it good to use your own information against you? How else will you know? Then if we go to the other element, if you turn around and you said now you don't deal in real estate, how do you look at it when you're providing advice to this particular person? Then also the final thing, okay, I'm going now to leave this case and I go to Tunga. There is an argument that we both agree on, but we reach different conclusions. We agree that withholding tax is not final. But it appears the taxpayers conclude that since it's not final, therefore don't pay it in these circumstances where the end result would result into me not bearing the final incidence. But for the taxman, my view is that since it's not final, why don't you pay it? Then we refund you. We can understand the argument that people say refunds are hectic, they involve verification, but I think you've successfully represented people in refunds that it shouldn't be an issue for fear. So my view is that if something is not final and it's temporary, and the law has created the mechanism for you, it's like you arguing that I will not pay 30% since my case has strong likelihood of success. I think you first pay the 30%. Then, like, if your case is so good like it was in Tunga, we will give you a decision and refund you. But you can't say that, it can't be that 30% is not payable for cases where they have such a high likelihood of success. No, the law is pay now, pay now, pay now. Then later on, we'll refund you. So in that regard, for Tunga, the analogy between withholding tax and rollover relief, my view was, if you're providing advice, let's say in that merger or what acquisition or that transaction, why wouldn't you, isn't it safer for you on that side to tell the taxpayer that pay the withholding tax, it's not final, then we'll refund you, instead of you aggressively saying we will not pay since the final way it's not going to be payable. Then that was for Mr. Kalema. Then for my senior, Oscar, I'm going to choose my words carefully. I wanted to, about legitimate expectation. And I agree with you. In Talo, I think it was presented and the tribunal didn't consider it. But I find a difference in legitimate expectation in Talo and that in Cambo. My view is that in Talo, I tend to agree that ideally there was as if there was legitimate expectation and there was good faith on both parties. But just that the point would be that if you look at our laws, maybe that section 14 of the Judicature Act, there is a hierarchy. And since legitimate expectation is a common law concept, my view is that where there is an act of parliament, equity, it should be the last. So if there is a tax law that is saying that all exemptions are supposed to come from parliament, they need to pass through legitimate expectation. It becomes, it has a where it has to stop. So even if the tribunal is deciding disputes, if the statute says something, I don't think we should push legitimate expectation above a statute. Now, in respect to Cambo, of course, some facts may not come out, but I think the aspects of good faith came out. You apply for an exemption, you say you're going to import machinery. After time, there is no importation of that machinery. You import rice. In my view, whereas it's not listed, I think some of the considerations they use to give you or not give you, if you indicate what you're going to use the application for. But if later on you turn around and use it for something else, that's when aspects come on of there's no good faith, automatically switching off, and so on and so on. And it comes to a fair hearing. So on that one, my point there would be that legitimate expression is good, but I think we shouldn't use it where a statute is there, because it would be now, it's a common law concept, really. Then on fair hearing, and this is a bit controversial, it's non-derogable. But if you look at even UPMAC, and that was the argument that 30% takes away your right to the fair hearing, and the Supreme Court agreed with the Constitution saying that no, that's not the case. Now in tax, there's this argument of fair hearing. If every decision URA has to make, it is supposed to call you and send you a notice to show cause, and they see it, and they tell you to present your side, and they respond, and then they make a decision. We may not purposively streamline the timelines. And for that, world over, fair hearing in tax is not the normal fair hearing in resolution of disputes, let's say labor matters and so much. The threshold is low, and also the way it is done, it's done in a way that if you disagree, you go to another forum and they handle. So my view, respect to Cambo in cancelling that certificate, maybe there are things that could be done, but if they are to call you and give you a fair hearing on each and everything, it would ideally become hectic. We may need more resources. So there are policy considerations for that. Yeah, so those were my comments. Jackie, I agree with you with respect to all both your discussions. But maybe my point regarding transaction value is that sometimes there are considerations on why not to quickly consider transaction value. Is that we are aware that with this technology, it's aware that the documents you bring, since the parties were not part of them, some people tend to look at them in a way to say, hey, your tropical heat, your transaction is like this. But when we look at American Garden, maybe in the same product, theirs is a bit higher. Why is it? So there are those considerations that people base on, but I think technically it's okay as it is. We should follow the sequential valuation methods. Thank you.
Thank you very much, Mr. Kalunji. Our time is fast spent, so my prayer to our dear panelists is that we respond to Mr. Kalunji's questions in less than a minute each, starting with Mr. Kalema. Your response to Mr. Kalunji's condemnation of Ugandans to dreaming small. Why does Mr. Nzei have 40 acres of land next on Entebbe Road?
Thank you. Thank you, Fatima. Just
something small when they holding land so that value goes up. I think during a minute's time there was that land reform decree. It's okay. Until hearing me. Hold the online. The land reform decree was supposed to stop those bad manners of people buying land and hoarding and then profiting and then the society getting enough. I think there was a provision that if we lease your land, you must use it. And if you don't use it, then the taxman comes around, brings in, we call them valuers, and we shall tax you according to the value the land has gained. Now, let's go to Mr. Nzei. Mr. Nzei has inside knowledge that the Highway Express 27 is passing around that place. Isn't that? So, he knows that if I buy my 40 acres of land, by the time the road passes there, value will have gone up. And therefore, I will make a profit. Unfortunately, the buyer is his own company. But the value has gone up. The taxman is not going to look at whether it is your property or private property. He's looking at the value. To me, I think as lawyers, we need to advise government to be strict on some of these things so that we get money. You are talking about the development agenda. This development agenda is not going to come out of sympathies and cheating and so on. It must be sacrificed. And they should have, I don't know whether they should sacrifice for the development. You cannot develop alone. Huh? And others, it's not only him. These real estate pharaohs, they go and chase away people in wherever. The value goes up. And they said, and they don't want to pay taxes. Really, is that fair? It's not. Mr. Kambona, you talked of exporting, importing, and then usage. I find something very funny. Uganda is common law. OECD is civil law. But some principles are palatable here, and we want to take advantage. Very good. East African community is embracing those jurisdictions, Rwanda. Why don't we sit down and really work out modus operandi acceptable in both civil and common law, instead of saying, arguing this, you arguing, so that we don't have time to waste. The taxman, Uganda needs the taxman to deliver the, for the development agenda. So we should put in place laws that facilitates that. Facilitate the taxman to collect the tax in time, deliver it, and then you can spend it. What do you think, ladies and gentlemen? Thank you.
Thank you very much, sir.
Over to you, Mr. Kalema.
Thank you so much, Mr. Kalonji and the gentleman. I'm not going to speculate on what Mr. Nzei may or may not have known at the time he purchased his land. And I'm sure you may also be interested to find out how much tax Mr. Nzei pays as an individual before we start pointing fingers of selfishness. But to address Mr. Kalonji's point, size of the land, size of an asset. Maybe, I don't know about my senior here. For some of us on this desk here, 40 acres is a lot of land. But for my senior here, Festus, 40 acres. 40 acres may not be that big. It is not something you would do as a business. You said you knew about Mr. Nzei's other properties. So, give a human face to your assessment. Put yourself in Mr. Nzei's shoes. Would he buy 40 acres just to do business? So, be that as it may, that argument was not the primary argument advanced by the taxman. During objections and actually during the hearing, the primary argument advanced was you are liable to this tax because you told us you deal in real estate as per your profile. That was the primary argument. If you had given Nzei an opportunity to show that this was not an adventure in the nature of trade, I'm sure that discussion, the tribunal could have considered that discussion. Lastly, I saw Justice Mubiru, I think this is the first time I saw him citing a decision, relying on a decision from the Tax Appeals Tribunal in the Begumisa case. But lucky for you, Justice Mubiru is no longer in the commercial court. He made the distinction of the land may be a business asset if at the time I'm holding it, it is being used by an affiliate for business. But that is distinguishable from what happened here. At the time Mr. Nzei was holding this land, Crown Beverages was not using it. If that had been the case, that argument would have fit in very well, that yes, you held it privately, but it was being used by your affiliate to do business, and therefore its disposal is business income to you. I think that's how I understood Justice Mubiru's argument. Finally, because of time, I want to address your concern on the Tonga nutrition case, and again, without breaching the sub judice rule. What I understand your argument to us as advisors, if a transaction is deemed by law to be exempt by law, we should still encourage the taxpayers to pay. So these days also taxpayers are also educated. So if the transaction is exempted by law, and in this case, again, we go back to Oscar's argument of giving a human face to the transaction. There is no cash exchanged here. The assessment is 600 million. Where do you want that money to come from? So, in this case, if the law is saying this is deemed not to be a disposal by law, then what authority do I have to tell the client, but you pay some withholding tax, it will be refunded to you? It is difficult. At the time of refund, we know what happens. You audit up to 9 years going back. That money, it will be difficult to get out. There was a meme which used to pass around. It was a leopard. It had like a trap on the head. And there were people surrounding that leopard. And the caption was, we want to help you, but your behavior. So, Mr. Kalonji, maybe you would consider that one. Thank you very much.
I have 1 minute, so I'll try and keep it brief. I'll start with the last. OEC guidelines, all these other external in civil law. I want to start by saying taxation has got several objectives. You know many. Key among them is revenue collection. And that's the point you're emphasizing. Let's try and get in more money for government. Fair enough. But it also has an advantage of stimulating economic development through encouraging, attracting investments. If you are going to restrict companies that are coming from civil law countries, and you're not going to look at international aspects of what's happening in other jurisdictions, how are you going to attract these companies? Are you going to rely on the NZs of Uganda to develop this country? And my point is simple. As long as a country we want to develop, and we want to develop using money from other countries, investors, business people from other countries, we cannot be only inward looking. We cannot only be working in silos. We must be broad-minded and outward-looking. Lastly, Mr. Kalunji, I agree with you entirely. Legitimate expectation is a common law remedy. It cannot become the number one point of resort. But in deserving cases, and I'm glad you highlight Talo, in deserving cases, I agree. I mentioned Cambo. I wasn't involved in this particular case, but when I look at the decision, the tribunal actually found that this taxpayer had made commitments, had acted on this decision. Now, where is the fairness here? You give me an undertaking, I act on that undertaking to my detriment, and you now tell me, wait a minute, tomorrow
All right. Good afternoon once again. My name is Mbekeka Vanessa Irene. I'll be your moderator for the next panel discussion, which principally revolves around transfer pricing and international tax considerations in Uganda. Transfer pricing, TP as we often abbreviate it, has become one of the most significant areas of tax practice, especially for corporates, multinationals, and as lawyers, it's an area that we have to actually pay keen attention to while we advise clients on cross-border transactions. Sometimes we end up drafting agreements between related parties. So today's discussion is going to revolve around what transfer pricing is, what arm's length principle is, how it actually applies, what are the various methods of transfer pricing, what are the misconceptions that lawyers have, what's the legal and regulatory framework, dispute resolution, cross-border and international tax considerations, and lastly, as most importantly, what opportunities lawyers can have in this space. We are fortunate to have a powerhouse panel today to discuss this topic, starting with Vivian Asuru. She's a manager in the transfer pricing unit at the Uganda Revenue Authority. It would be very good to have insight from the regulator. We have Anne Basho Kengaju. She's a tax advisor from KPMG, one of the big 4 audit firms. And lastly, we have Andrew Chambade. He's a tax partner at Godena Associates with over 13 years experience in tax practice. You're all very welcome. Thank you for honoring the invitation. So let's dive right straight in, And I'll start with Vivian. In simple terms, what is transfer pricing? Why should lawyers actually pay attention to what transfer pricing is?
Thank you very much, Vanessa, and good afternoon, lawyers and members of ULS, and also the members online. As introduced, my name is Vivian. I work with the URA, and our work basically is to check TP compliance to international tax and TP rules as provided for in our laws. So when you come to transfer pricing, what is it actually? Simply, transfer pricing is an accounting and taxation practice by which companies set prices as they transfer property or services between themselves. And it doesn't necessarily only happen between multinationals. It can even be within a company itself. Different divisions within the company can, maybe one transfer goods to another division that needs to produce. Let's say the raw materials production section can transfer finished goods to the warehouse section. So the rate at which they transfer that is still a transfer price. But when it comes to the taxation element of it, the interest is in groups, entities that are affiliated or associated with each other. And from a tax perspective, you can also have local groups as well as multinational groups. For local transfer pricing, you find that because it is within the same tax system, undergoing the same tax provisions, there's not much of a significant risk, because then you find what is being reported as income on this side is an expenditure on the other side, and it is under the same tax system. What picks then the tax administration's interest is in the cross-border transfer pricing, where it's happening between members of multinational groups, and they're transferring either property, tangible property or intangible property, and then services. Services can also come in various forms, can be normal management services of HR. It could be technical services such as IT and the like, or technical expertise that one member of a group, let's say in Singapore or somewhere in Europe, is providing to, say, a taxpayer or an entity that is affiliated to them here in Uganda. So that price, that rate at which they either transfer, that is through transferring from the foreign jurisdiction to Uganda, or Uganda could also be providing, sending an item of property to the other entity affiliated to them overseas. That rate at which they do is the transfer price that is applied. Thank you.
Thank you, Vivian. In our previous panel discussions, there's been a common notion, the arm's length price. People have said it over and over. For custom purposes, once you're clearing, what's the arm's length price that you've bought from a related party, like like Vivian has clearly elaborated. So I'd like to bring it to Anne. Could you elaborate or explain what exactly the arm's length principle is, and how are entities able to determine that the price they're charging is actually arm's length?
Thank you, Vanessa. Good afternoon, ladies and gentlemen, both physical and ones online. Well, as you rightly stated, arm's length price or the principle keeps on coming back when it comes to international transactions. And simply put, the arm's length principle seeks to, or it's a foundational rule that helps us to determine, or requires us to determine, what the price between independent entities would charge in comparable transactions. So you have, let's say if you have a company for beverages and they are, say, trading together, they are related entities, they have a price, which is the transfer price that she has made mention of. And then we also have independent companies that may do the same transaction. We may say they may have comparable circumstances here and there, and then they have their price. So the arm's length principle that we always talk about seeks to determine whether, when we look at the independent entities, does their price reflect when it comes to the related party entities, or what we would call the controlled transactions. So why this is a very important subject or concept is that when we are trading together and we are related, we'll most likely try to manipulate things to favor each other or to promote one's business. Usually when we talk about it, we'll look at it in terms of trying to shift profits, evade tax. It may end up in that, but also it also gives an advantage in terms of trade to the related entities. But at the end of the day, yes, sovereign states or the jurisdictions will try to grab whatever they can in terms of revenue and taxation, and that's why you see all these BEPS going around. But also, on the other hand, we would want to promote fair trade. You don't want to have certain companies taking over an industry simply because they have these economies of scale coming up and benefits here and there. So that's essentially what the arm's length principle is trying to help us curb when it comes to the shifting of profits or unfair trade, or what it helps us to understand when it comes to transfer pricing. So how is it determined? One, we're going to have to look at what exactly that transaction is. That is the basis of determining the arm's length price. Yeah. So we want to understand what the controlled transaction is. Why? Because when it comes to looking at the comparison in terms of the independent entities, then we need to also look for transactions that are similar. Because much as you may be thinking that, okay, we are comparing maybe this beverage company X with that's doing an independent transaction with business company Y that's involved in a controlled transaction, we are not comparing the parties. We are actually looking at the transaction. So when you are looking at the transaction, you understand what the functions are, what the assets are, what the risks are, all involved in that transaction. That's the basis or the beginning part, the foundation of determining what the arm's length price is. And once you've actually gotten a comprehensive understanding of that, then now we move to determining how do we, like the methods really of transfer pricing, how did you arrive at that price? And the methods essentially are listed explicitly in the international conventions, as the OECD, and then you also have the UN Model Tax Convention. And like the previous speakers mentioned, Council Kambona, some are persuasive, some we have actually adopted into our domestic legislation. So what are the methods? Briefly, I'll just digress. In the interest of time, I'll digress a little bit. There are 5 traditional methods, and that's the cap, the comparable uncontrolled price, and then there's the resale price method, and then cost plus, and then we have the profit methods, which is the TNMM, transactional net margin method, and we have the profit split methods, yeah? So when we're looking at those methods, we are basically trying to find out which is the most appropriate method. And how do you find that out? We get back again to the functions, the assets, the risks, and whether the comparability is easily derived by simply looking at the goods. So if you have goods that are comparable in terms of the volume, what they actually are, maybe television sets, you may find that it's easy to find a comparable being transacted with independent parties. And so with that, you may say, well, use the cap method. Or if you're looking at loans, for example, you will use the cap method because most of the times the CBR is clear cut for everyone. And also when it comes to benchmarking and the guidance from the OECD, you'll see that the cap method is actually the most preferred for loans. When it comes to services, you'll also most likely consider cost plus method, but in practice we'll end up with the TNMM because there'll always be these twists and turns in the transaction, in the service, and so you may not find an exact match from the independent companies. So besides, I'll not get deep into the methods, at least I've explained what it is, but key to note is that also we'll have to look at the comparable, or we'll have to look at the comparability analysis, which I find very key when it comes to the concept of the arm's length principle. Why? Because when you're looking at the functions and everything I've mentioned, I'll not repeat myself, one, you need to look at it in terms of the characteristics of the product. Very key, because you don't want to be comparing apples to tomatoes. You need to compare apples to apples. And then also looking at the economic circumstances. You may find that when URA comes to check out the documentation, they also need to look at the circumstances in which you transacted. Maybe the reason why you gave that discount to your related party entity was simply because it's not an appreciated industry at the time. You want to find your way into the industry, penetrate through it. So you decided to do a certain transaction a certain way. But also, that's okay, maybe for the business strategies, but economic circumstances may also be the geographic area and all that. And then also looking at what the contract says, but as the earlier discussion was, that we're not going to only look at, let's say, what you documented, but what exactly is on ground. So much as in terms of comparability analysis, we are going to look at the contract and what your intra-group contract state and whatnot, we're also going to try to consider what you actually did on ground. So in summary, that's really the arm's length principle. We are trying to look at the related party transaction vis-a-vis the independent transactions, and then draw a comparison to see whether that transfer price that was charged between the related party entities actually meets the arm's length test. Thank you.
Thank you, Anne. Summarily put, the arm's length principle is quite important, and you've ably discussed the different methods that are applied. And in order for Vivian not to come after you, transactions between related parties should actually be arm's length. Now I'd like to loop in Andrew. Andrew has a certificate in transfer pricing and very heavy expertise in transfer pricing as well. So I'd like to understand from your international tax law practice or experience, what are some of the common misconceptions lawyers have? I know in Vivian's introduction, she said, when she was describing transfer pricing, she said something about accounting. And accounting and lawyers are not best friends. So I just want you to elaborate for our viewers and listeners, what are some of the misconceptions that lawyers and businesses have about transfer pricing?
Thank you so much, Vanessa. The team, my land colleagues, both physically here and online. Transfer pricing as a subject is a very interesting area, especially for the lawyers, because it is not just law per se. It centers more around economics, first of all. Then it has elements of accounting. And eventually, having merged those, then the judgment is required. And as we all know, we don't judge things in the same way. It's not so easy to give a uniform perception for the lawyers. Normally, in practice, I say we have tax lawyers and non-tax lawyers. So the perception, with due respect to the non-tax lawyers, I've seen some elements of biasness, which is coming normally from the thinking that this is a very difficult area to practice. And sometimes people just fear what they don't know, right? If I use that word. And the misperception about this is no transfer pricing, there's not so much law, there are things of calculation and accounting, you need to understand the business right from the boardroom, right from the strategic directions and decisions that are being made, which in a way has hindered the practice of transfer pricing by the legal fraternity. But again, there are also majority who appreciate this area. The other perception I've seen equally in practice is the subject matter of transfer pricing. Like when you look at it, for example, in Uganda, of 2011, which are not more than 20 pages, if my mind serves me right, and the practice note of 2012, equally we all know the effect of a practice note in terms of binding and authority. We are left with an option of picking the best practice, being the OECD transfer pricing guidelines, and our regulations are clear as updated from time to time. I've seen a common misperception, and I'll just mention among others 2 or 3. One is the thinking that transfer pricing deals more with tax avoidance. All that when the URA, I think I've also seen this in practice, when an officer is auditing your client and sees a related party transaction, they say, you even have a transfer pricing problem. Ladies and gentlemen, just because related parties are doing business does not per se mean that there's a problem. The general standard, as my colleague has discussed, is the arm's length principle or the arm's length price. As a matter of fact, even a transfer price can be an arm's length price. So that misconception that just because parties are dealing, so it's meant to appear like when related parties do business, there's actually something that is being hidden, which to me is a very negative perception. Transfer pricing as a matter of concept and legal requirement is about fair allocation of profit to enable the taxman pick a fair tax. It is about fair pricing, costing, and all that. It only goes to the extent of tax avoidance if those are done in a manner that takes away the tax base. The other misconception also I've seen that is very common is when applying the arm's length principle, even in the normal casual corridor talks, we always say transfer price is the price set between related parties. So whatever is the opposite is the market price. And I want to tell my land colleagues and ladies and gentlemen, the market price is not per se the transfer price. Even when this bottle goes for 1,000 Uganda shillings, between independent parties, it might not per se mean that it is the transfer price. Reason being, a market price is going to be arrived at based on a number of factors, especially the cost in terms of input. But the transfer price and the guidelines, we are looking at mainly the functions that are being performed to entitle you to such a price, the assets, the risks, and all such other considerations. So you might find that whereas this bottle of water independently would go for 1,000 shillings, when we trade it with Vivian, who are related, the transfer price is actually 800 Uganda shillings. So the market price gives a semblance of an arm's length price, but it is not exactly the same at all times. So that also I've seen as a very common one. And maybe for the businesses also that I've seen in practice is documentation. Sometimes, and it's a very common thing to everyone who does business, when we're doing business, you're chasing that profit. And you can always come back and do the documents later. We have the sharp lawyers who can do everything backdated and also sign backdated. With technology today, I can sign a document of 1998. So transfer pricing actually does not require that you do that way, because each time you're going to rely on a memory, chances are many that you're going to meet the formal requirement, but in terms of substance, you could be lacking. So the real situation would be that whatever documentation you're looking at should be a contemporaneous document, a real-time document with a real-time justification. So in the interest of time, one, transfer pricing is not about tax avoidance per se. Each time related parties transact does not on the face of it mean that there's a problem. And I've seen this a lot when you're doing audits, even the normal audits. Number two, the market price might not necessarily be the transfer, the arm's length price. And in terms of documentation, the conception is accountants, we have year end and we have 6 months to audit and also file a return. You find that it is within the 6 months that we are doing the documentation. I've represented a client where a transaction took place about 2 years ago. They only had an invoice. And now the URA was querying the prices in the transaction. And I'll tell you, URA asked us to provide information within 30 days. But in those 30 days, we have to prepare a sales agreement, we have to get bank documentation and all support. And it is nearly impossible. So those misconceptions, I'm a very good lawyer, I can draft as fast as I can use AI. No, please. And maybe just one minute, the key thing also for the local entities. There's a misconception that transfer pricing deals with multinationals. And please, for clarity, Uganda is unique in a way. When you read the transfer pricing regulations, which is not actually so common, Uganda looks at in and in entities and in and out entities. So even when you are a local entity and you're within a group, and the value of your transaction is more than 500 million Uganda shillings, documentation is a very important symbol. Now, there's a very small gap there. There's a difference between satisfying the arm's length requirement and documentation. So even when you do not have a compulsory requirement of documentation of 500 million, still below 500 million, you must meet the arm's length dealing as you're doing your business. Thank you so much.
Thank you, Andrew. That was quite thorough. I just want to now move on to Anne. If there's one thing we've noticed is the tax laws keep changing, yeah? And as practitioners, as lawyers, we must be attentive to that. So one of those is there was a recent amendment on the definition of a branch, yeah, which was now changed to a permanent establishment. Could you maybe clarify on what those changes are and the implications they have on the businesses here in Uganda?
Thank you, Vanessa. So yes, the financial year 2024-2025, we had the change coming in that brought in permanent establishments. It's not exactly very new because the old law also had it, but embedded under the definition of a branch. It was not, should I say, sufficient when you compare it to the international conventions and the descriptions they are in. And there was a bit of maybe uncertainty in certain areas. And so what that amendment brought in was whatever is in the international conventions was more or less adopted explicitly in section 78A and B as it then was, and now it's 77A and B. So what changes? One was maybe using a permanent establishment as a description for the section, and expounding on the definition, because when you look at the new provision, you'll see that now a branch is more or less an example of what a PE is. And that's what was in Article 5 of both the OECD and then the UN Model Tax Convention. And so the definition then also brings in a bit more, should I say, clarity in terms of the breakdowns. You have the farm and plantation, of course the previous definition had consultancy services and all that, but this definition sort of brings a bit of a broadened definition. But one of the key introductions in there was the exclusions. When you read the conventions, you see that there's certain things that are excluded from the definition of what a PE is. And so moving on to what we introduced into our law was bringing them now from the conventions into the Income Tax Act of Uganda. And so that includes, say, the use of facilities for storage purposes, for display. But key to note is that they should be of a preparatory nature or auxiliary character, meaning they're either supportive or used or services that you're just doing to prepare for the core business. If it falls outside that and we determine that it's actually part of the core business, then you're going to have a PE being established, and definitely it comes with tax implications, as we'll see later. So with that, with the exclusions, of course, we also have another provision, which is a sub-section under 77A, which is the anti-fragmentation rule. And like Andrew said, when you think of TP, you definitely think of profit shifting. There's some tax avoidance here and there. And so that provision, looking at how it came about from the conventions and then into our income tax law, is that the OECD and all those international bodies were looking at the different tax planning mechanisms, which we would call aggressive by the multinationals, to avoid having a permanent establishment. So you have maybe an establishment in Uganda by an MNE, and they are claiming to have no existence of a PE simply because maybe they are doing activities that are seemingly of a preparatory nature or auxiliary nature. But then when it comes to the anti-fragmentation rule, we're trying to curb that. We're trying to say that, okay, if we look at your transactions wholesomely, when we look at them, are they preparatory? Or are you somewhat saying they're preparatory, but we are seeing a core business activity being done as well that would create a PE? Again, getting back to my previous point that I mentioned, sovereign states are trying to grab whatever they can, their share, their rightful share of the cake, that's the revenue. So with these anti-fragmentation rules coming in, we're saying that, okay, you may have, for example, a construction site, and an MNE may rightly so say, I'll come in, I'll do a few activities for maybe 30 days and pull out, and then come back later and do maybe another 40 days. I'm still under the 90-day threshold, and so you can't say, well, there's a PE here. But then they'll come again and do something maybe for another 25, 30 days. When we look at it in terms of the aggregate period, does it actually meet the threshold? If it does, then URA would be right to say that we see a PE being established here, and so they would have to, of course, exercise their right to collect the tax due to them under the PE. And to mention that the PE concept, really, why they brought it, when you read the explanatory notes, it's simply to ensure that whatever income the non-resident has actually earned in Uganda that's attributable to, the PE should be taxed here. And so when you see with the anti-fragmentation rule, which I find very, very key and one of the most important actually introductions in that provision, is that it gives URA the mandate. Of course, it already has it to look at the economic substance, but also to see with certainty that, okay, These are what clause, rather subsection 4, agrees to as being preparatory. This is what you've done and your core business is X. Then if your core business actually exists in Uganda, done by your PE, you should pay the taxes due. And away from that, we also see that it brings clarity to the definition of what a dependent PE is, or a dependent agent rather is. So initially it was there in 77.8 as it then was, that if you're a PE and you're doing work for your principal who is a non-resident, then there's a PE being created, but it wasn't very clear. And so we see the introduction of that provision for dependent PEs being introduced and being expounded on. So if you're habitually concluding contracts on behalf of your principal and there's not much change from the principal, you're habitually manufacturing and processing on behalf of the principal, or storing goods or securing orders on behalf of the principal, then there's an agent PE being created here in Uganda, and so there'll be tax implications. And I believe that these are provisions lawyers should actually take note of, because you may be approached, or you're often approached to do tax planning. So if you're not aware of the details, your planning may actually implicate your client in terms of creating for them a PE, an agent PE. But also, besides that, we also see a clear definition in terms of what an independent agent is. Yes, it was also mentioned in the previous law, but here it's should I say, expounded upon. And as long as one acts exclusively, even if they're doing the work of the principal, but there's that exclusivity. You're not working entirely, if I may say, for the principal. You're doing your ordinary business, you're in your ordinary course of business, and probably you've provided a service to the principal that may be considered as an independent agent, as opposed to the dependent who literally does everything per the principal's instructions and all that. And also, key to note is still under 77A, is the separate entity, or what I usually call the fiction that comes around. In terms of corporate law, you'll see that the branch, even when we register it with the URSP, it's a registered foreign entity here in Uganda. You want to sue it, you're most likely going to consider the head office and all that. But when it comes to tax, we consider that it's independent. It is, if I may give a layman's example, it's like a subsidiary. Before we consider the head office, we are looking at it. And so it now comes out explicitly in the law. Before, yes, it was there, but it was, should I say, implied. But now it's clearly stated that it's distinct, it's a separate entity. We can sue it for taxes, and that's a URS side of things. And it has to comply, it has to have its own policy, it has to, as long as it meets the requirements, and if it's from an M&E perspective, it definitely does per the practice note. And so with that, let's move on to maybe section 77B, attribution of profits of the, or determination of the profits of a permanent establishment. Yes, previously the branch would definitely, as we all know, comply, it has its team, files its returns, it can be audited and all that. But now here we have the law coming out to clearly stipulate how to attribute the income of a non-resident person that's connected to its PE. And so with 77B, we are able to determine what amounts to the chargeable income of a PE. Besides that, what deductions are allowed for the PE and what's not allowed for a PE. And of course, key to that was the fact that certain payments, for example, the royalties, the commissions, the technical fees, while they are not allowable deductions, on the other side, they're also not considered when we are computing the chargeable income of the PE, which is, should we say, fair enough, but not exactly fair enough. But yeah, you give, you take, or you give and not take. So besides what is those express deductions that are not allowed. At least we know that the provision also came in to say that, yes, on the face of it, P is like any other person being a definition under the Act, is allowed to have deductions for all those expenses that they've incurred in the generation or production of their income. So I find that very key and something that lawyers, because you're key players when it comes to advising multinationals or group entities, should take note of. And yeah, I think that's majorly it for the changes that came in the amendment. Thank you.
Thank you, Anne. And I think that's a testament to what Senior Counsel Osakambona mentioned earlier, that we cannot operate in a vacuum, because this amendment is literally us picking from the OECD Model Convention and implanting it in our domestic law, which is probably something that the policymakers could consider subsequently to actually become members of the OECD. I would like to, Andrew, you initially told us about the misconceptions lawyers have. You mentioned you had to prepare documents within 30 days, yeah? So when clients come into your space and you have to draft for them these documents, intergroup agreements, service agreements, IP licensing, yeah, those kind of documents, what are the red flags lawyers should look out for? What are the important considerations that you have to take into account when you're drafting this documentation, so that the client doesn't find themselves on the red side of like non-compliance or anything like that?
Thank you so much, Vanessa. I think the principle should be probably if you are an investigator and you intend to catch a thief, you need to first understand the tricks that the thief uses before you go in to get them. As a grand principle, if I'm going to do any document review or draft, I need to know the user of this agreement. I'm not going to use it myself. I'm not just going to have it for keeps. But the tax authority, among others, especially for TP, is a user. So I need to put myself first in the shoes of Vivian and the team. That if Vivian found this document on the shelves, or if she asked for this document, what would she be looking out for? And for me, I would say Section 116, the Commissioner General's power to distribute, allocate, or reallocate, or deny any deduction, is exercised where the Commissioner deems that the chargeable income that you're reporting does not reflect what would be achieved under an arm's length transaction. It means the grand principle of all my drafting, all my review, would be that when the Commissioner General, and I mean even Vivian, looks at my agreement and also understands my business, she should be able to derive or reach at a conclusion that I meet the arm's length requirement. That is the general picture that every lawyer drafting, reviewing the agreement should aim to achieve. Now, what is very common as a pitfall, normally at the point of drafting, save for the time factors, sometimes what I've seen common is you read an agreement and you do not see any business sense as to why these people agreed this way. What in transfer pricing sometimes we call commercial rationality. Some company A, let's say, is not doing so much business, and it's not using maybe a software or intellectual property of any kind, but there's an agreement in place where this company on a monthly basis is paying such large sums of money to, let's say, the parent company or such other company who is the owner of the IP for the use of this IP. And there's a very valid contract there and then. I want to state that today, in the modern day today, the times of the Duke of the Westminster versus IRC have since ended, where every taxpayer has a right to so arrange their transactions in a manner that derives less taxes. We are since past that era. So if an agreement is being reviewed or being drafted and you do not see any business sense, I can assure you, Vivian will start making assumption that perhaps you're moving a profit or a revenue, or you're trying to push a cost at some point. So the agreements that we draft should be able to make commercial sense. They should make business sense. Would a prudent, ordinary businessman allow to pay rent for a property they're not occupying, rent which is at such an amount as compared to their revenue during the year of income? And if the answer is no, there's a problem there. So the commercial and business sense of the transaction. The other one, I cannot overemphasize the need of the substance over form requirement. I know, and I've lost a case before the tribunal before, where I have a valid agreement, the agreement is even registered, it has even paid stamp duty. And to me, I'm safe. I'm like, no. If Kalunji comes out, I'll say, what are you asking for in this transaction? But then when you go into the nitty-gritties, okay, Andrew, we are seeing a loan here. Can you see the bank statement? There's no money moving. The closest I can urge you as a lawyer is, but there's no law which stops cash transactions. And at the time you're making that argument, you know you are a drowning man who has to cling on a serpent. So the form of the document or the agreement must reflect the realities. And the realities must be the realities in commerce. You cannot be saying we are doing this in the agreement, however registered, however valid, however well drafted, and the reality is the opposite. So transfer pricing, in fact, the recent OECD, the post-BEPS OECD updates, they are saying look beyond the form of the contract, however well and however valid. Look at the economic activity that is being done and the benefits and costs that are flowing over that particular economic activity. So to the drafters, to the reviewers, the substance of the transaction is what matters. You will not fault the URF for trashing your agreement and then looking for such other information to validate the would-be transaction. So that is also something that is a common, we normally focus on the format, and sometimes the history of our practice. There's one member who mentioned about the Amin era, and he seemed very familiar with the regime or the era. I'm not so much familiar. But we have a historical thing in drafting of templates. Lawyers, many times you receive calls from colleagues, can you give me a template? Can you send me a template of this? And I'll tell you, transfer pricing, templates, and copy and pasting will not work. I've also done a case where it's a transfer pricing defense I was doing. And in one, I would assume it was a copy and paste because the taxpayers draftsperson for the policy said, looking at this transaction, we are going to apply the cap. However, we think this cap will not be the good method. Therefore, we concluded by applying the TNMM. And I'm thinking, okay, you say you're going to apply this, but again you discredit it, and then you come to this. So during the meeting, they asked the taxpayer, the URA side said, but you see, you've said cap is what you're going to use. The taxpayer said, no. For us, our position is TMM. We have not even mentioned cap anywhere. And in the meetings, I also came very sure that I'm defending TNMM. The gentleman projected and said, but Chambade, your policy itself is saying cap. So the copying and pasting and the templates, we must use them cautiously. So if it's a TP document, if it's an agreement, if it's a management fee, you must make sure it is original, I would say. Yes, we are in the era of technology. Lately, I tried to test as I was preparing for this. I said, ChatBT, can you prepare for me a TP policy? And I was amazed. In 30 seconds, the policy is done. And I'm like, how? How is this possible? So as we go about technology, as we go about templates, as we go about copy and paste, maybe let's copy, paste, and modify. Maybe that's better. But substance, the commercial business sense, the copying and pasting in terms of documentation, those are very, very serious ones that most lawyers need to be very cautious about. And who is the user of the document? Don't draft for yourself. Whoever is using it, when they read it, they must feel that you have met the arm's length principle, and not artificially, but in actual business sense. Thank you.
Thank you, Andrew. Basically, one size won't fit all, right?
Yeah.
All right. So, Vivian, yeah, we understand the Commissioner General has the power, they have the authority to recharacterize these transactions that it feels like in Andrew's statement do not make economic sense or they have no substance. Yeah. So from the revenue perspective or the tax authority's view, what are some of the biggest compliance pitfalls that taxpayers fall under or fall into when it comes to transfer pricing?
All right, thank you, Vanessa. And at the heart of a transfer pricing audit or review or the TP analysis that you do for your clients, the taxpayers, you're supposed to be able to demonstrate to the URA that you complied with the arm's length principle. And that means there's a lot of documentation that is involved. That is from the point of the agreements, like Andrew elaborated on, from the point of the agreements to the policy or the documentation, like the TP reports. How do you describe that transaction? How did you go about confirming and checking that you complied with the arm's length standard? And you find most times the documentation that we request, and also to clear any misconception, we do not just request for transfer pricing information and documentation from each and every taxpayer. We first undergo our own internal reviews and analysis. Is this actually a taxpayer that has cross-border transactions? Yes. If they have cross-border transactions, from the information we have, are they worth having a second look at by contacting them, or from what we see, there's not much? So there's a preliminary risk assessment that goes on with respect to transfer pricing or the cross-border transactions that we see from the information we have. So when we ask for this information, most of the times when it returns, it is really, at times it's lacking, okay? Like Andrew has mentioned, many times there are instances of copy and paste or using a template. From the agreements to the policy or the report itself to the other information that you may provide to support it. You find there's instances of copy and paste, and when you read this policy that you've been provided with, it is not speaking to the entity that you're looking at here in Uganda, the local entity that you're looking at. And you find most of the times the policies, because you're part of a multinational group, there's of course what you know as the master file and the local file, but probably it was prepared from the perspective of the group, okay, of the parent entity or the service provider. But then that due diligence or that check to come and see, yes, we are providing services, this range of services to an entity in Uganda. Are all these services as in the group policy the same as the services we are delivering to the local entity? Edit out some of it and keep it to what is happening. But because when now you start providing each and every detail, or even in the agreement, you find an agreement for royalties, okay? Maybe you're licensing the use of the trademark. They list each and everything, each and every benefit being rendered, each and every activity. But then when you go into it and with your understanding of the local entity, you find that it's actually not applying. So one of the key pitfalls actually is around documentation, okay? Its insufficiency or it not speaking to the circumstances in Uganda. And then when you come to the TP report specifically or to the TP policy that you submit, you know, as you defend your price that it is arm's length as a taxpayer, at the same time you're supposed to benchmark it. Did you do an internal comparability analysis, or you did something, an external benchmark and the like? And you find most times the focus and the emphasis is on the benchmarking that happened. And you find in a 100-page report that was submitted, 80 pages of it is on benchmarking, plus the annexures and the like. But you've not enabled the taxman to appreciate the industry. Which industry are you in? How are you organized as a group? How do you transact with each other? even you've not gone ahead to explain the transaction, to describe it, the transaction itself, to detail, to help the taxman appreciate that transaction you're dealing with, how you've allocated your functions, your assets, and your risks. You've not explained how the services are flowing, if they are services, or what the obligations of the provider is, and what the obligations of the recipient, or what the recipient is expected to do, and all that. So you find most times that is lacking, and of course then that's what leads to assumptions that when URA comes, maybe they just want to raise an assessment, they want to come up with additional tax, they want to find a problem even when there's no problem. But the beginning of it, have your documentation in order, and then when it comes to now the actual execution of the audit, okay, you've been selected for audit, we have sufficient grounds or basis to think that probably your transactions are worth looking at. Then we come, of course, one of the intensive processes, the fact-finding, which most is either through doing a site tour or visit, and also through doing functional interviews. And these functional interviews, usually we might be in your faces a lot and interview quite a number of people, but it's all geared at trying to understand what goes on, what the facts and what the circumstances are for the local entity, okay, with regard to the transaction that is being reviewed. And so you find a number of times the advisors, which would maybe include the accountants and the lawyers, are sort of a barrier to this process. But that barrier sometimes becomes an issue that causes us to biases the audit process and makes us make conclusions that may not be appropriate to the facts and circumstances of what is going on at the local entity. So collaboration and facilitating that process of the fact-finding and what is helpful, and it is most times helpful to the advisor and the taxpayer, because then it enables the URA to be able to make a more informed decision and come to a reasonable conclusion regarding the review of that specific transaction. Then at times also, when you look at the appreciation of the matters, probably an area that we both need to improve on, you find that TP is still a developing subject matter in Uganda. We do not have sufficient guidance. Like he mentioned, our TP regulations are maybe about 20 pages, but then again, we give, we committed ourselves as a country to check, to make sure we apply it in a manner that is consistent with the OECD guidance that is available and as it is updated from time to time. So it is important as we challenge each other, because at the end of the day we grow and we learn from each other. As we challenge each other, as we are doing our side of ensuring that you're complying, that the taxpayer is complying to the TP requirement, the arm's length requirement, on your side also you're doing your best to make sure you can demonstrate, okay, to the URA that this price that I have charged or that has been charged on me is actually meeting the arm's length requirement. Thank you.
Thank you, Vivian. That was quite elaborate. Now, we know with taxes, there's always a dispute going to arise because a taxpayer is going to say, no, this is my price. And the URA is saying, no, this doesn't seem like an arm's length price that you've charged your related party. So, Andrew, from your experience and daily practice, what trends have you observed in transfer pricing disputes? Have you handled objections? Are matters being settled before they reach the courts? How exactly could you paint a picture for us?
Okay, thank you so much, Vanessa. I must say this transfer pricing practice area, actually the first time I thought it is a very serious area from the tax authority's perspective, around 2017, if not 2018, URA sent different taxpayers a form called Related Party Disclosure Form. And I remember representing or helping out some clients fill that form. And indeed, when you could see the questions or what the information being requested at the time, you could really think that, okay, after 2 or 3 years, there's going to be a lot of running around. So in terms of trends, I must say the curve is up. The international tax team is well beefed, unlike as it was before. And Vivian is here. I see Mark is there as well. I see the legal team is available. It speaks volumes about how serious the authority is about this subject. So, like she has said, normally in transfer pricing, you could do, you don't just come and audit the way normal audit happens. You first do a TP risk assessment review using the different tools, either internally developed or per the guidelines. You find you review maybe 40 and it can only zero down to 2. It does not mean that there's not so much behind the scenes, but also remember for every review you're picking information or a trend or something. So there's quite a lot happening behind the scenes, and I have to applaud the authority. Really, capacity building is well up there. And in terms of objections, I don't know what others think, but for me, what I've seen in practice, maybe it's a culture for Ugandans. Each time there's an assessment, a client comes to you and says, I want you to object to this assessment. It looks like objection is an auto right for our clients. But sometimes even say, no, but when I look at this, I don't think you have a point at objection. Someone say, no, but it's my right for you to put in the objection. Then sometimes you think you need fees. So if you choose not to take on those instructions, you need to have some costs for running the business. So you also object. But well, you know that for sure there's not so much that you can crack. So I would say the objections definitely, because it looks auto for the taxpayers. But what I've also seen is there's a lot of settlement at ADR level. The authority is recognizing, and this is my analysis, that TP is a developing area. We have a law that is okay, it is good, but you'll find that most of the things we are picking them from the OECD guidelines. So where a taxpayer comes clean and you want to speak to the different adjustments that have been done by the tax authority, and you can reasonably demonstrate or find a win-win situation. I've seen quite a lot of settlements at the level, which is actually within the law as part of negotiation. So that is also a very good trend, which is upward. I think when you look at the URA report for last year, there's a lot of cases settled at ADR, unlike the previous years. But most importantly, when you have my colleague Prida in the house, you have Tony, I see some, definitely litigation, they're well armed. So when you think you don't want to sit down and have a win-win situation, we are going to the tribunal as the first course of instance. And normally, sometime I asked, how come each time we have an international tax case, they send people who have actually done international taxation? So the leadership or the team at administrative level is much aware that, oh, this is an area that needs some bit of specialized knowledge, specialized support, and litigation is actually happening. I think we've seen recently, there was a decision, with due respect to Tony, sometimes I don't want to discuss cases which I have not argued, but there's a case of CIMEC Investments Limited versus URA, which more dealt with allocation of costs between the head office and the subsidiary entities. So when you read really the quality of that, the arguments, you really see that yes, litigation is happening, like CIMEC had taken that route, but also the team the other side is very ready to have these discussions and make all the necessary adjustments. So the trend, I would say, like the minister said, is it's going up, and it's a very positive trend. The taxpaying community should be ready to defend in case of disputes, but the authority is well equipped and cases. But of course, because we say TP is not so much law, sometimes I say, you see, when you read section 116, it's the only law in the act. Lest you have the regulations of 2011, 14 years old. And you have a practice note of 2012, which binds the Commissioner General, right? That's a legal effect, if my mind serves me right. If you have an opportunity, you're defending things of business and commerce. What happened in the board meeting? Why are you receiving this much money for the brand? Why did you say this software values this much? judgment, the commissioner could be overzealous or yourself could have been over or underzealous. So sometimes if ADR is an option and you have a platform or an opportunity, I think it would be the better platform, notwithstanding the fact that I believe so much in ADR in resolution of tax matters. But the trend is very positive and it's all good so far. Thank you.
Thank you, Andrew. I feel like you've spoken on behalf of the practitioners and the URA. So I'll just move to Anne. Anne, how do you advise companies to mitigate some of this costly litigation? Andrew mentioned a client comes, they want to object, and you're looking at fees. So how can companies actually avoid getting to that point where they have to object? I know sometimes it's inevitable, but there could be steps that they could take to mitigate this.
Thank you, Vanessa. Well, I believe that mitigating this starts from the moment the client gets to your office to engage you. Why? If you understand and appreciate your client's case, your client's, should I say, facts. For example, if they require a TP policy, if you're understanding their sector very well, you understand the entire value chain very well, what that will lead to is that you'll end up preparing a robust documentation, because what we see when URA comes around and, you know, they're more or less issuing assessments in regards to transfer pricing, it's because the documentation that is submitted does not really capture the whole value chain. Most of the times you may focus maybe on the transaction, looking at it maybe in the perspective of the Ugandan entity, and yet when you understand the entire sector, you understand the value chain, you're most likely going to have a robust documentation at the end of the day. And so even when the audit comes, which is inevitable because they'll definitely audit whether or not you've done a perfect job, but what that will do is that you'll at least mitigate the fact that, or the risk of them issuing an assessment. Then also, I think we need to explore more in terms of the advanced pricing arrangements or agreements. To the best of my knowledge, we have maybe a few that are ongoing. Trying to engage URA here and there to, you know, enter into an advanced pricing arrangement. What that does is that it creates certainty that if we transact the way we've agreed in that agreement between the taxpayer and URA, we've agreed, say, to transact in a certain way, to charge a particular price, then at the end of the day, when you read the regulations, should be Regulation 9 of the TP regulations of Uganda, then you'll find that the Commissioner General is actually bound to confirm what you've done as long as it tallies with what's in the agreement, and also not issue assessments or try to switch the position, because they're bound to it. But we've not really seen one, or at least to the best of my knowledge, being fully executed, signed and, you know, in force. But I believe that it's one area that we could use. It creates certainty, and at the end of the day, you know that if you follow to the dot, then there's no need for an assessment to come around and ultimately going to court. But also, I think it's been mentioned in the earlier discussions, if we are able to help the clients to operationalize their documentation, at the end of the day, just that act actually helps to mitigate the risk of getting into disputes, because getting into disputes starts right at the point of an assessment being issued. But what culminates into that is some ill preparation here and there or documentation. So if the agreements you've drafted for your client do not correspond to what's being done on ground, as Vivian mentioned, they'll definitely come around, and much as you have your documentation beautifully done, they'll conduct their own interviews. They'll try to understand what is done on ground besides the contract. So if the two do not tally, you're going to have a change in your documentation or adjustments being made which will lead to getting into court. So helping your client make sure that the agreements speak to what is being done is very, very key. And also helping your client keep that documentation. If there are meetings that are being done, or the way they request for the service or the goods, whatever it is, all that documentation should be kept, because at the end of the day, the burden of proof falls on the taxpayer. If you're unable to prove what your allegations are, then an assessment will come and we end up in court. But besides that also, I believe training your clients is very key. You, as a lawyer, you don't sit, okay, besides the in-house lawyers, but the practitioners who advise, you don't sit with the client 24/7. So meaning, while you're going about your business, the client may maybe perform a certain transaction the wrong way, yet had they had that TP knowledge, they would probably have recorded that meeting, kept that invoice, maybe ensured that the execution of what's in the agreement is actually duly done on ground. So I believe that training the clients also is one of the ways you would mitigate. It may not be direct that, when you train, then at the end of the day, there's no assessment, but it indirectly assists to mitigate that. And yeah, I believe that's it.
Thank you, Anne. And I would love to hear from our regulator's perspective, Vivian. What's your take on the advanced pricing agreements? How can taxpayers utilize this to mitigate some of these disputes that they actually have with the Revenue Authority? And the second question would be, does URA actually collaborate with other revenue authorities when it comes to transfer pricing enforcement, or now some of these agreements, because they cut cross-border?
Okay, thank you, Vanessa. And Anne mentioned that our Regulation 9 of the TP Regulations 2011 talk about APAs. So it's within any taxpayer's right to write and apply to the Commissioner General to go into an advanced pricing agreement for consideration. Okay, so you submit your application with whatever you're proposing, the transactions you're covering, the periods that you would want that agreement to run over, whether you want it to be unilateral, that is between the Revenue Authority and yourself, whether you want it to be multilateral or bilateral, all that is within your scope and rights as a taxpayer. And we do have APAs ongoing and running within the URA. They've been applications have been made and they are under review. If you may not also across Africa, not many countries, I do not even think there are 2 or 3 countries that have either APA regulations or the law in their domestic legislation, but that have actually also concluded APAs. You will appreciate that transfer pricing tax, from the tax administrator's perspective, is still a developing subject matter. Still a developing subject matter, and maybe sometimes the tax administrator is apprehensive, or is not certain of how. I have no insight into how you're operating or how your transfer pricing practice is, and you would like me to commit myself to 5 years, okay, of a certain set of parameters and terms, such that, and then that locks me in. I'm not able to come and make an adjustment or review because I've committed myself or locked myself in for 5 years. So that kind of care is there, I think, across Africa. But then the developments it's progressive right now. You find Kenya enacted their APA law just recently, yet in comparison to Uganda, people think Kenya is more advanced in tax administration than Uganda. Uganda, we've had it, but yes, the applications were also not coming through. But now, due to capacity development and also maybe increased activity from our teams, in terms of handling transfer pricing. The applications are now coming through and they are being considered. And consideration of the APA application will end up in either confirming and agreeing to what you're proposing. It may end up in a modification, or it could end up even in a rejection if we do not really agree to what you're proposing. So that is an avenue that is available and within the taxpayer's means to request for. In terms of your second question, collaborations and maybe cooperation with other tax authorities and other international bodies, URA does actually, not just URA, but Uganda does actually collaborate and cooperate with both other tax authorities, but also with other international tax organizations. If you look at organizations such as the OECD, the UN, the tax committee specifically, you look at the World Bank, you look at IMF, all those have elements of tax expertise and tax regulation of for different countries. So URA does, and these entities actually do influence or provide assistance to the tax administration process internally, but also they provide tax policy support. So you'll find some of them, like IMF especially and World Bank, have a lot of influence on our tax policy. Some of these are amendments and improvements in our law. Some of them are recommendations from such bodies, which of course then the URA comes and implements. But also in terms of capacity building, you find the same organizations, including the ATAF, which is the Africa Tax Administrators Forum, also comes in to give support, capacity building in terms of technical capacity, trainings, learnings, sharing of information, and the like. And then other collaborations, still international frameworks and agreements. Of course, you know, we do have tax treaties in place. In these tax treaties, there are articles that allow for sharing of information, okay? Like Article 26 in most of these treaties allow for sharing, for requesting for information. And this information helps us in making tax decisions. Because we are dealing with multinationals, you find sometimes we'll ask the taxpayer here in Uganda to give us information, both that which they have and that which are held by their associates overseas. And sometimes maybe they do not have control, or they are not able to convince their counterparts, so their associates in another jurisdiction, to provide the information we want. Yet we need that information to be able to review the transaction appropriately and make a tax decision. So in the event that the taxpayer here in Uganda is not able to give us that information, then we are able to make an exchange of information requests using the different tax treaty networks we have in place. But also, if you may be aware, we have the Convention of the Mutual Administrative Assistance in Tax Matters. That was also a law that was domesticated or placed in our domestic laws, I think 2023-2024. So that also within it, and that comes by virtue of us being members of the OECD Global Forum. Uganda is a member of the OECD Global Forum for exchange of information and tax transparency. So there, you find there are other avenues that the URA can still use and collaborate with other tax administrations to either obtain information or to get assistance in recovery of tax that has already been assessed, or to do a tax examination abroad, or to do a simultaneous tax examination. So all these bodies, ATAF, Tax Inspectors Without Borders, which is for UN, OECD, you look at World Bank and all these other entities and organizations, plus tax bodies. In East Africa, we are concluding on the East African Treaty. Okay, all those are ways to collaborate. Then also internally, you find we have, within tax administrations, we have communities of practice where we share, because you know, taxpayers who are part of groups across East Africa, they have presence across Africa, across other regions of the world, they have presence. So you find you have those communities of practice to share experience, to share knowledge, to consult each other on different matters. So, yeah. That would be my response. Thank you.
Thank you, Vivian. As we wrap up, we just want to briefly discuss the opportunities for lawyers, and I'll start with Andrew. Andrew, what opportunities exist for Ugandan lawyers when it comes to transfer pricing and international taxation?
Okay, thank you so much, Vanessa. I think all of us here are agreeing that at the heart of transfer pricing is documentation. And documentation, there are legal standards and requirements. So every lawyer, there's a job available in terms of enhancing compliance with the quality of documentation, the drafting of such documents. I know in law sometimes we say the devil is in the details, but with transfer pricing, vague and unclear terms are very risky. So we have an opportunity of drafting such documents and agreements for our clients, and also helping them to comply with the law. Also, as lawyers, we are advisors, and as advisors, we help before the transaction. We help these clients on how to structure these transactions and what they're planning to do, especially M&A issues that can trigger also TP. And also in terms of structuring, how should the transaction be at the end of the day that should be complying with the arm's length principle. Further still, we have an opportunity in terms of policy. We cannot underestimate the role of a lawyer in policy formulation. The Ministry of Finance at the other end with URA as the competent authority, they will be working around in order to make sure they update either the regulations or the APA now that Kenya has done something. I know even our side we will do something. So at that point, with a clear understanding of the OED guidelines, which is the bigger picture from which we are deriving all these, and also the business mind and the legal mind, it's such a very good opportunity for us to help the government in drafting some of these. And then lastly, as a practitioner, at the end of the day, capacity building. And it comes from two angles, either on yourself or as trainers, or in terms of helping other people improve their knowledge in this area of practice. So the opportunities are really very many for the lawyer, both the lawyer in on the side of the authority, the lawyer on the side of the arm of government, the executive, or at the legislature level, even the judiciary, but also the private practitioner who is helping these clients. Thank you.
Thank you, Andrew. I would like to thank all the panelists for a very insightful discussion on transfer pricing, and would like to close the discussions and maybe open the floor to any questions. Please help us with the mic.
Thank you all for the presentation on the, called it TP. I almost thought it was the other thing. But in the course of discussions, I've learned something new. My interest is on, well, we have talked of collaborations, we have talked of working together and so on. What is the relationship between URA, manager transfer pricing, with our colleagues in Financial Intelligence Authority and Bank of Uganda? Because I think ultimately those three must collaborate. Two, it looks this transfer pricing looks to be a multidisciplinary undertaking. So an accountant must be there, a lawyer must be there, maybe an auditor and an investigator. Because I think I don't know, how are you doing the training here in URA to be able to fuse those functions so that they work in harmony? Because these fellows are very, very intelligent, especially those who come here to invest. The man will declare something on the other side and come here and declare something, confuse you. And in the end, he will come to take off, the repatriation of all the profits and funny excuses. Lastly, we have been talking about the TP regulations. Can I access a copy, because I think I've never. Is there where I can go and get a copy of these regulations? Thank you.
Thank you, sir. Senior Revenue Collector. So, Vivian?
All right, thank you, sir, for your questions. I'll start with the last one. The TP regulations are part of the Income Tax Act. They are compendiums that are available on the market. However, URA is in the process of compiling as of the last amendments, and a soft copy will be available on our portal, I think by next week, from what our teams have said. So you could go on the portal and download yourself a copy, but also on the same portal there should be an old copy, which I believe still has the TP regulations compendium. Okay. Yes, the second question was about the multidisciplinary nature of TP. It is true, and in URA and specifically for our units, you'll find we have lawyers, we have accountants, auditors, economists, and other scientific areas, disciplines. So that is, yes, we do recognize that for TP you need a combination of all that to be able to manage that compliance better. So thank you for that comment. In terms of the relationship between URA, Bank of Uganda, and the Financial Intelligence Authority, there are still also frameworks in place and collaborations in place that enable us to share information. Most of the times I would think it is URA that benefits more from it, though that is not exactly under our mandate for TP, but in case we have a department called the Tax Investigations Department that checks mostly tax evasion. Our part is more of tax avoidance. TP is under the anti-avoidance, not meaning that if you're transacting with each other, you're avoiding, but it is a possibility. That is a tax avoidance scheme. It's a possibility. So, but for evasion, our tax investigations department handles that specifically, and they're the direct liaison with the financial intelligence. But then, of course, internally we do cooperate, and if there's information we needed for a particular matter we're handling, we can get, and the same would apply to Bank of Uganda, because all these are government agencies. We should be able to support each other and collaborate on matters that affect us. Thank you.
All right, thank you, Vivian. In the chat, there's just a vote of thanks from Senior Counsel Cephas Birungi. Brilliant submission, Kingaju. Thank you all for listening. Thank you to our panelists. Yes, we'll move on to the next session. So we are a bit behind on schedule. So we'll just have our last presentation, and then we can close, we'll have lunch, and then we can network and leave at will. So, ladies and gentlemen, our next discussion turns to an important and really timely subject, which is prosecution as a tool to combat tax evasion. Obviously, we all know tax evasion remains one of the biggest challenges for the URA. They are trying day and night to see how they can close up all the revenue leakages they are. So while compliance strategies, audits, administrative penalties exist, the role of prosecution still stands as a huge and powerful deterrent to tax evasion, and basically a signal that tax evasion actually has serious consequences. So we are fortunate to have Ms. Diana Prida, who will share her expertise and insights on how prosecution is being used as a mechanism to combat tax evasion. Diana Prida is the Assistant Commissioner Litigation in the Legal Services and Border Affairs Department of the Uganda Revenue Authority. She's an advocate of the High Court with over 12 years' experience in both tax and commercial litigation. And she's also a member of the Chartered Institute of Arbitrators. So hopefully within that prosecution, there's some peaceful talks. So please join me in welcoming Diana to make her presentation. Thank you.
Good afternoon, everyone, and thank you, Vanessa, for that generous introduction. Coming last and at 1:30 p.m., it is not an easy task, and so I'll try to keep my presentation within time. The topic for discussion is indeed prosecution as a tool to combat tax evasion. It goes without saying what the mandate of the URA is, that is collection of revenue, and in performance of that duty, it I think I can leave it. Let's leave it. Yeah. Sorry. So in the process of that, it's required to administer and enforce compliance with the laws. As URA, we work on the premise that taxpayers are generally compliant. We believe that taxpayers want to comply and try to comply, and therefore we shall not seek to prosecute as a measure of enforcement of first resort. We have put in place a number of measures to enable taxpayers to comply, and these include tax education, sensitization, engagement. We have client relationship managers for different taxpayers, even the design of our business, having targeted divisions or sections to handle specific taxpayers, all aimed at making it as easy as possible for taxpayers to comply. And that being the case, we'll only resort to prosecution as a last resort where all else has failed, or where there is blatant abuse and tax evasion. And in that regard, some of the considerations will be what is the prevalence of the crime or offense, what is the impact on revenue collection, what public interest considerations are there. For instance, I think we all know about some skin cosmetics which have been banned in Uganda. There is Carolite, which have mercury in them, skin lightening creams. And so there was a time when it was really rampant. They were being smuggled in because they're banned, and would had to come in and prosecute as a way to deter the practice, but also because it's in public interest. Because someone then would ask, why is URA interested in Carolite or these bleaching creams? It is, other than the fact that they are prohibited, it is really, these are going to impact the public if they're let in. URA is also, in a way, charged with maintaining the security of the borders, and it falls on us to ensure that these things do not come in, especially prohibited items, which would impact on the health of the citizens as well. We'll also look at who is committing the offense, and generally the aim is that at the end of the day, the result of prosecution will be to serve as a deterrent, but also to encourage compliance. And in this regard, some of the common tax offenses we see in customs include under declaration, false declarations, being in possession or acquiring prohibited and custom restricted goods. Some of these include cigarettes, we see supermatch, we see banned, the bleaching creams I've talked about. We see all sorts, phones and custom smuggling. I think we've seen them at the airport, people strapping them on their bodies and the like, so that's very rampant. We see making false declarations at importation, certificates, application or documentation. We also see some fraudulent evasion schemes. And so that's one where parties, agents, the taxpayers, and other people will, with intent, fashion schemes to evade tax. And the other one is conveyance of uncustomed or prohibited or restricted goods. Why this is prevalent is obviously the goods have to move, and so there will be a mode of transport. And it's commonplace for drivers to say, I'm just a driver, I didn't know what I was carrying. But the nature of these offenses is that they're mostly strict liability offenses. You should know or to have known. It can't be that you're just called, I was just called and goods loaded into my car, I don't know what they are. You should know what you're carrying, you should know that it's proper and who has given it to you to carry. Otherwise, your car will be forfeited to the state, and that will be it. So it's also a commonplace, so we always urge transporters, be careful what you're carrying and be sure that you should be carrying it. And then we have interference with goods subject to customs control and making false entries. In regard to common offenses under the DT laws, the most common would be failing to furnish a return. We're yet to, I think we've prosecuted 2 or 3 on that, but we would say this is really something that we help, we are resolving by helping taxpayers comply, and hopefully that goes down. But more prevalent and ones for which prosecutors have been conducted is making false or misleading statements to a tax officer. This covers the offenses of having false receipts, false returns, anything really that has false information that is submitted would fall under here. And in this instance, we've seen tax practitioners, lawyers, not lawyers really, but agents, come up with 4 documents. I think in one case, the document in issue was an acknowledgement receipt where the person was tasked to make amendments. And instead of making amendments in a system, they came back with an acknowledgement receipt purportedly to prove that they had made the amendments, and therefore that the assessment or the decision we had taken was wrong because they'd made amendments. We're able to verify, to validate, and find out that the document he had presented was fake and had not been issued by our system. And so we went on to prosecute that matter, and in court his defense was, but the taxes were paid. But it was the principle of if you can go to such length as to forge a document issued by a system instead of complying with your obligations, it speaks to a more sinister intention. We've had instances of obstructing tax officers in the execution of their work. URAs operate sometimes in hostile instances, and we are fortunate that there have been few of these, but some have included physical altercations. More recently, we have offenses under the DTS and IFRIS, such as failure to affix or activate tax stamps, and these are subject both in the tribunal. We've had instances of, but also for prosecution, because again, the aim is compliance. We had a time where it has been efforts to sensitize the public, where there have been engagements and penalties were being issued until such a time as it became a matter of, I'll be caught, I'll pay a penalty of 50 million, I can account for that in my business, go back to it. So prosecution is key in ensuring that there is a deterrent sentence, because if someone is either imprisoned or charged to a fine, they'll think twice before going back to it. What has come through from all the discussions that we've had for the past 2 days is the importance of documentation as far as tax is concerned. On both ends, you cannot have a proper assessment, you cannot have a proper proof as a taxpayer to challenge a tax assessment if you do not have proper records. So it's a requirement under the law that you have maintained these proper records, and where you do not, you can be charged for the same. There are also offenses for IFRIS. I think it came up yesterday in discussion where someone said, if I'm not registered and I'm not a taxable person for IFRIS purposes, and I don't issue the receipt because anyway the tax is payable, what would be the recourse? It is an offense not to use the electronic receipting and invoicing system, and whereas there might not be an implication on the tax end, you'd have committed an offense, and protection might be one of the tools to ensure compliance with that. And so it's important to note that even with prosecution, the tax does not abate. Is a misconception, not a misconception, it's generally a defense that people try to raise up every time they're quoting this. The premise is that they will argue, but the taxes have been paid. But the premise is, what has compelled you to pay the tax? It's, in instances, the law is clear, Section 85 of the TPC, tax does not abate by reason of prosecution or conviction. But also, trying to say is, whereas you want to front it as a tax, it is the principle, the action that has led us to this prosecution. You can't have brought in forged documents. You can't have engineered a scheme, fictitious invoices, made up transactions, blatant lies, and then turn around to say, but I've paid the tax. So taxpayers and tax practitioners to advise their clients that whereas it is their duty to comply and to pay tax, prosecution will not wipe away the tax and will still collect it even after there's been a conviction. In terms of mitigating these offenses that we've seen, a number of measures has been taken, as I've highlighted before. We've had introduction of IFRIS, DTS, we've enhanced penalties to be more deterrent, and currently I think for making false and misleading statements, the penalty is 5,500 currency points, which would translate to 110 million shillings if you're convicted of the same. But we've also increased collaboration with other agencies. For instance, Senior Collector talked about FIA to get more information on such offenses, the schemes, to be able to address them, and also increase reliance on the use of technology and forensics to detect and also to aid prosecution of those. But as we progressively make these measures, we also continue to see the mutation and prevalence of these. One of the areas upcoming, and I think I saw it in one of the questions of practitioners, as practitioners, and in that regard I'm referring to both lawyers and accountants, we have a duty to advise our clients, but to advise them correctly. Where it is you're found to have advised wrongly, or where you're liable for the actions that lead to the commission of the offense, you will be taken on personally. And there are offenses in the TPC to cater for this. For instance, it's an offense to hold out as a tax agent when you're not. And we've had to prosecute some accountants who, rather than do their duty honorably and advise clients on what to do well and ensure that documents filed are proper, have taken it upon themselves to help the clients forge documents, make false returns, make false invoices, for purposes of evasion. And so it's something that we are coming out strongly against and encouraging tax practitioners to advise accurately and ensure that their clients are on board. And so, in a nutshell, that's what we've done as in terms of prosecution. And the takeaway is that whereas we have the rights and we can prosecute, URA prefers to think that taxpayers are compliant. We will continue to work to enable and facilitate taxpayers to comply. But if that fails, we shall not hesitate to prosecute to ensure that the appropriate revenue is paid, proper taxes are paid, and that there is fairness in the system. Thank you.
Thank you, Diana, for that very elaborative presentation on prosecution as a tool to combat tax evasion. I'll open the floor to any questions. Those online can put their questions in the chat.
Why not?
Thank you, Senior Revenue Collector. Prida will take that question as we wait for further questions.
Thank you so much. You've asked 3 questions. I'll begin with where do we prosecute these matters. The URA, the legal department, has special licenses to prosecute tax offenses. And by legal notice, tax offenses were gazetted as corruption-related offenses. And so prosecution of all our tax offenses is at the anti-corruption court, and that's where we take them. You've also said you've not heard of any citizen taken to the University of... Okay. There have been a number of convictions, and indeed there have been imprisonment. There are quite a number. I'm not sure that you would know them, but we've had Grace Mwanje serve 3 years. There's a more recent one of 8 years, and another of period. It's currently still on appeal, but people have indeed been convicted and sentenced in terms of the results of prosecution. The other question was how effective has it been, or how have we used the tool? So in terms of statistics, we currently have ongoing 100 cases under prosecution at various stages, some at initial trial, others that are on appeal, just a few. But as of last year, if we just say last financial year, close to 83 million shillings recovered in terms of fines, but also taxes recovered. Earlier on, we talked about when they said about some amicable resolutions. In most instances, when the evidence is adduced to the non-compliant taxpayer, they will opt to enter into a plea bargain. And that would be an amicable or an ADR resolution of the matter. And it's always a condition precedent, really, where taxes evaded or taxes lost as a result of this non-compliance or offense should be paid as an indicator of goodwill in terms of settling the matter. And in that regard, taxes of over 1.2 billion were collected last year from such instances. But also under the TPC, there's a provision for compounding of offenses. At any time during investigations, but before we commence prosecutions, taxpayers are encouraged. You know what you did. We were not there. Please, this is your opportunity. If you come out before we commence voluntarily, and there's even voluntary disclosure, you come out voluntarily and say, well, this was a mistake, or have taken note that this didn't go well, I would like to rectify. There is a provision for compounding. And under the compounding agreement, which also acts more or less as a conviction or order of court and is enforceable, it's a requirement that you pay the taxes and then a fine, and it would also be another way of resolving. So again, to encourage taxpayers out there, if you know that there could be any challenges in your affairs or issues that are not upright, to take benefit of the voluntary disclosure programs and to take benefit at the earliest before prosecution is commenced to ensure that you're compliant, and we do not have to kick in prosecution to get that compliance.
I hope that will enhance the correction. So that is the stick method.
All right, there's another question in the chat. Why is it that the whistleblower policy is not respected? There have been instances of people whistleblowing and disclosing instances of blatant non-compliance, but rewards have not been forthcoming.
Thank you. At least the question is not that we are not acting on the information provided. Regarding the rewards, there is a process. It's not just whistleblowing or providing the information. It has to be verified, there has to be an assessment, and there has to be a collection before we can then go into whether payment or reward should be made. And the process has been streamlined, and I doubt that there are any instances where you've given verifiable information which has led to collection, where URA has not worked on it. We encourage people to whistleblow if they have such information. And if you have any issues regarding payment of rewards, to approach the URA so that the same can be resolved. But we do appreciate that that's a key tool in fighting non-compliance.
All right, thank you. Thank you, Prida. Thank you for the questions. And if there are no further questions, I see a question from Paul Muhimbura, but it's not directed to this presenter. Anne, I'm not sure if you're willing to take this question. He's basically asking, just requesting to throw more light on amendments of a branch and permanent establishment. Should we?
Could you kindly scroll down so I could read the question?
Just as Anne prepares to answer, please, everyone in physical attendance, please utilize the QR codes to register so that you ULS can take note of your presence and code you CLE points.
Okay, thank you. Throwing more light on the amendments for branch and permanent establishment. Maybe something that I may not have directly mentioned is in terms of the determination of the profits. One, you'll see that the amendments bring in the force of attraction rule, which is simply that whatever activities are done by the non-resident, as long as they're done here in Uganda and they are similar or somewhat connected to what the PE is doing, then you're going to have that being drawn into the PE chargeable income pool. And the reason behind that, simply put, is that, again, each jurisdiction is seeking to have its fair share of the cake, which is the revenue. And then maybe to stress the fact that when it comes to PEs, you need to be very, very careful, because much as the confusion we've seen maybe in other jurisdictions is that you may have a subsidiary here that's operating and it doesn't have much to do maybe with the non-resident entity on the face of it. But as explained earlier, the transactions being done may actually establish a PE. So you'll have the subsidiary and you'll have a PE being created. So that's something that tax advisors, the lawyers, could actually take note of, that when you're advising a client or doing the tax planning, it has to actually be very clear what they do, how they do it, and what the repercussions will be. Yeah, I find the question too broad. I would end up going back to what I already said, but I'll leave it at that. Thank you.
Thank you, Anne, for that clarification. So to bring this to a close and just to wrap up, to thank all our panelists and presenters today. We started off with M&A tax issues. We moved on to key recent tax decisions, transfer pricing, and lastly, prosecution. You have been an engaging crowd. I believe we've all learned a thing or two. So we also need to appreciate ULS for putting this together and look forward to further fruitful discussions. Thank you.
Guys, hello. Let's have a group photo, then we go for lunch, please. Yes. Guys, please don't leave without scanning the QR code. Please don't leave without scanning the QR code. Advocates, please don't leave without scanning.